and this is right out of Wtda's, the intention is the soul of the instrument. Meaning, an instrument can be a written agreement, it could be a negotiable instrument, some kind of a bond showing evidence of debt, but anything that facilitates the performance of a contract can be considered an instrument. And the intention behind it is the soul, meaning it's not the expressed words in the document that are the nature of the document. Meaning, you've heard, like, if you meant for the contract to be one thing, but the way that you wrote it out, it was construed and interpreted as something else. This is when the conduct becomes so important in the contract. I watched an episode of Judge Judy. Anyone ever watched Judge Judy? And the two parties come in, one was a landlord, one was a tenant. And the landlord wanted back rent from the tenant. And they had an expressed written lease agreement where the tenant agreed to pay, in the document, $2,000 a month. But from month one, the tenant only paid $1,800 or $1,600 a month for 6 or 7 months. And now this landlord was attempting to get the tenant evicted for not paying this back rent. And the tenant's position was, my rent was $1,600 a month. I've paid. I'm in honor with the contract. And Judge Judy says, well, first the landlord wants to argue and wants to show, here, Judge Judy, this is the contract he signed. It's got his signature on it. Okay? Judge Judy looks at it. Is this your signature? Yes, Your Honor. Okay? She then asks him, what was your understanding of the contract? Well, I understood that I was going to be paying $1,600 a month. I didn't read the contract. Then the landlord, well, it's his duty to read the contract. Right? It's your duty to know what agreements you get yourself into. Judge Judy looks over at the landlord. Did you accept the checks for $1,600? Well, yes. Well, what did you do with those checks? Well, I deposited them. Okay. Judge Judy found in favor of the defendant, the tenant.
Did the landlord ever give notice prior to going to court on a monthly basis that the check was short in that particular case?
Not every month. It wasn't until about 4 or 5 months that the landlord started asking for, what he called the back rent.
Would you say then, in simple terms, that...
But a new contract was created every month that the landlord accepted the $1,600, no matter what the landlord was saying. This comes up because people who are working on like their mortgages, their cars, credit cards, you start a private commercial process, right? And so you're establishing a new agreement. And then you receive another statement in the mail. Okay? The statement shows that you owe money. Even though, let's say, you've done a money order, you've done an A for B, you've done a bond and promissory note, you've done some kind of private negotiation with your own money that you created to set off this debt. But now you get a bill or a statement of account showing that they didn't credit you for your private instrument. What happens when you hold on to that statement of account for 30 days without responding? So you validated the debt.
What you can say in simple terms is, you said the intention is the soul of the contract, right?
The soul of the instrument.
Soul of the instrument. So would it be fair to say that intention or motive is determined objectively?
Absolutely. Judge Judy saw it that way. She saw that it was the intention of the tenant to pay $1,600, that it was the intention of the landlord to accept the $1,600.
What if the landlord, just out of quick curiosity, What if the landlord, instead of just bringing the agreement, nothing more than testifying, which you're not supposed to do for their own case, had brought a monthly statement showing that they were short to $400 each month and it was continuing to accruing? Do you think it would have been a different outcome?
It depends.
Could have been, right?
It could have been.
But the landlord was only in there saying, yeah, I took $1,600 for the last 4 or 5 months, but this is our agreement that was done 4 or 5 months ago with nothing in between, right?
Right.
So, we see this all the time. We see people just alter their agreements and their contracts all the time. It's much like we talk when we kid that Ben Franklin, when asked coming out of the Constitutional Convention back a few hundred years, was asked, what have you given us? A republic if you can keep it. And what we kind of play on that a little bit and say, what have we given you? A contract. Or what do you have? A contract if you can keep it. You say, no, it can't be that hard to keep it. Au contraire. Actions do speak louder than words. And what Brandon's trying to explain to you is very simplistic. His contracts are just moving all of the time, or they can move.
They're dynamic, they're fluid.
It doesn't mean they are moving. They move if you want. Mortgage companies used to do, some of you can recall that for a while there, when you couldn't make a full mortgage payment, you could send in a partial mortgage payment, I'll catch it back up at the end of the month, or with a car company, I can only make a partial payment. And pretty soon people got wise to that, and they started going to court saying, look, my house payment was $3,000, I sent them $1,500, they agreed to keep that, that's the new contract. And the courts were sticking those people with that. So you often find now the mortgage companies often will not accept any partial payments. So contracts are dynamic, they can move. And they will move. On what basis will they move? Because this is going to go to fundamental what he's talking to you about. What you keep doing, or what many of our students, friends keep doing, is they keep moving the contract. We had a recent guy that was staring at being in federal prison. And this gentleman, we had gone in, done a fair amount of paperwork, and submitted something back May 20th, the day of sentencing. And he was looking at getting 5 years or so. He's a basketball player out of California, dealing with some OID money problems. He's in jail for that. And we put forward some things. It was like over $5 million, and he spent half of it. But he wouldn't tell him where he spent it or whatever. The long and the short is, he was going to be sentenced May 20th. We put in something that said we wanted to fix. We were going to go back and fix the civil dishonor that was done with IRS regarding that. And the judge made comments beautiful on the record that obviously there's a man of honor and integrity in there. We're going to see if there is, and that kind of thing. He gave him 60 days. And we told him, okay, now what you have to do is go back and fix the problem. And instead, he hooked up with this group that will fix things behind the scenes for little or nothing, supposedly. Well, July 8th came. Sentencing. They hadn't done a thing. And he hadn't done a thing. And the judge went from being courteous and kind and a good man to, it's obvious that you're looking at some jail time. You've made no effort to do this. He warned this guy up and down, back and forth. They still didn't want to fix it. They had faith in this group that fixes things for nothing. Or little or nothing.
And if you're looking at, if you espouse the ideas that we espouse, which are that we are responsible for everything that we create, that as creditors, that's something that we take on. These are principles that we live by. That as creditors, we take full responsibility for everything we create. And as such, we don't look for other people to solve our problems. We look to solve other people's problems. We don't have problems. So if I get an IRS statement showing that Brandon Adams owes $250,000, well, I have the opportunity to assist the IRS in settling an account.
I think Jack says it real clearly. Creditors work to solve other people's problems.
And if you're wanting to be a part of something where somebody's going to do it for you. That's what, in my idea, and the principles that we espouse, that's being a debtor. That I'm not responsible, I can't handle, I'm not competent in handling my affairs. And we're seeing a lot of these people who are hoping someone's going to swing in and save the day and do everything for them. They're not getting the remedies because they're showing their incompetence.
And to finish that story, this guy didn't fix it. He got a 2-week warning. He went to sentencing yesterday. They gave him the maximum they could give him. And they said he hadn't done a single thing to help him do it. At the previous hearing on May 20th, when they said, we need you to pay this back, and he says, you got all my money. Must have had no ink left in
The
his
judge said that it appears as though there's a man of character in the
Integrity and honor.
And so the judge postponed sentencing for 60 days so that number 6 is man times 10 is the law. He can demonstrate that he was a creditor, a man of character. And in that time, after that hearing, well, during the hearing, after the judge said, I'm not sentencing the defendant today, the judge made that comment based on paperwork that he had put in there showing that he was trying to sell off, selling clothes and everything. But then the judge came back immediately and he made a statement. According to the record, it appears as though you still owe the United States $2.5 million that has not been recovered in the refund that you got from the OID. Are you going to help the United States get their money back? And he looked at the judge and he made the statement, well, you guys pretty much got everything I've got. Does that sound like a creditor or a debtor? And I'm surprised why then the judge didn't change his mind in sentencing, but they gave him 60 days. So when they took him back to jail, Gordon and I learned about this. We told the people on the outside that were the connection, that would get information to him, that you better be ready because in the next 60 days, they're going to send somebody to your cell and interview you because the judge wants to get a report. What kind of man is in that defendant? Is it the man of character who is going to be a creditor and help, or is it going to be a debtor in there? Because he had excellent paperwork which delayed the sentencing, but then he made that stupid statement that came back and said, you pretty much got everything I've got.
Now, this guy called me regularly, so for the first couple of weeks, when he did that and I heard that, he said, no, I know that was stupid, I shouldn't have done that.
The judge had 3 visits sent to his cell in the next 60 days. The first one was an investigator which came and just informally was saying, well, you know, would you like to help the United States get that money back? Well, if you understand you're a creditor, you're going to do a full acceptance, and if you haven't done it before, you're going to authorize a set-off with your asset account. And it's a done deal. It's history. But he was going with things like, well, is the court going to give me an order to work with the United States?
Are they going to order me?
And the investigator's going, no, we're asking if you're going to help us with this. And the guy is going, well, if they're not going to give me an order, I'm not going to volunteer. A man of character, a creditor, a debtor. First time. That's what he said. They went back and, whoa, this isn't going well. Came and visited him a second time. Same thing again.
With a witness this time.
And he blew off the same thing. And the witness, who's now the U.S. prosecutor that went with the investigator, that gave him the opportunity, he changed that.
Because can see how this is an example of conduct changing the contract. You know, a lot of people out there will fill out documents thinking that that's going to make them a creditor. You know, if I fill out a UCC1, if I fill out a security agreement, that makes me a creditor. You know, your conduct makes you a creditor. And in this case, this gentleman had documents that identified him initially as a creditor, and then without conducting himself as a debtor over and over again.
The problem is we gave him those documents. So he might have been a creditor had he adopted the stuff that we gave him, and he had a copy of it. Let's let Jack finish the story.
The third time that he was involved with the court, he was in front of the judge. And that was yesterday for the sentencing hearing. And Gordon called up his friends last night because we went online to see if the court had put anything in the docket sheets yet. And they had not, but one of his friends called back. And these are the people that have been kind of ignoring Gordon and I for the last 6 weeks. Because after we had helped him put the paperwork in, which got the judge to say there is a man of character that might be in that defendant, they elected to go with someone else. And they haven't told us who, but we believe it's the ones that are promising, well, you don't have to do anything, we'll take care of it for you. And so, I don't have to do anything. I can relax, my future is secure. Is that a debtor or is that a creditor? Because if you are incompetent to handle your own affairs and you've given it to someone else,
Again,
you are a debtor.
Again, competency, capable of handling one's own business.
Capable of understanding contracts and being able to move the contracts, not only to settle your problem, because your problem in the contract doesn't go away until you settle their problem in the contract, which is why you were involved with them.
Part of the contract is offer and acceptance.
That's correct.
And they got offered
performance.
And he got offered to pay the 2.5. Hey, we need the 2.5 million.
We need performance. If you're going to be a man of character and go home instead of going to prison, you need to help the United States get the 2.5 million. Now, this is not an issue dealing with whether OIDs are valid or not. That was not what was in front of this court. What was in front of this court is that this guy got brought in on an alleged charge that he didn't do something right, and he never rebutted the charge. So since he failed to rebut the charge that he did something wrong with an OID, under the maximum law, failure to rebut it means you agreed you did something wrong. So what this is about is fixing the wrong you agreed that you did, even though it probably wasn't wrong. So it wasn't about whether OIDs are valid or invalid. It's about the fact that he never rebutted what he did being okay. So he had a duty and an obligation, or he's going to prison, and he would not fulfill the duty and the obligation. So he got sentenced to the maximum, because for 3 times the court gave him an opportunity to come and act in that role and conduct himself like a creditor, and he chose to, somebody else is doing it for me, I don't have to worry about it.
Now, we had a comment last night from the person that reported back to me about what happened.
Yes?
And that was a very nice comments they made. Maybe you could elucidate or...
There were a lot of statements, and they basically were, well, the court is out of hand. The court is doing whatever they want to give. They didn't give this guy the benefit.
It's just a show, right? Just a show.
Yeah. They punished him merely because they're using him as an example to stop everybody from OIDs. And it's like, well, now that we see that his friends all have this debtor mentality, it's easy to see where he gets it.
What kind of hunt did they call it?
A witch hunt.
But we know it wasn't a witch hunt because he's a guy, so we know it was a warlock hunt.
That's right. So they needed to applying it correctly. But the point we're making here is that if it appears as though something isn't working in your life, you are probably not doing it correctly. And the other side has a fiduciary duty to protect someone who is incompetent. So if you're in a commercial scenario and it is not working well for you, it's probably because you've been deemed to be a debtor incapable of contracting to protect yourself. So like Brandon said, you look like you're contracting, but since you do not know what you're doing, you don't have any contracts. And they just invalidate or void everything you're doing. And they're doing that for one reason, to protect you, because it's now an exigent circumstance, it's an emergency, you don't know the law, you aren't applying the law in your life, so the law has to come down and protect you. And when it protects a debtor goes into servitude for a period of time to work off his debt. And that's what we're seeing happen.
It's a critical principle to understand that we believe. The government always does it right. And that's really hard to swallow, especially when you're suffering privations or being attacked as you think it, or you're not handling your offers well. Believe it or not, it's so important for you to understand that simple concept. If you're not getting your remedy, it's because you're not doing something correctly. Now, also, and Jack and I and Brandon have all seen this, it will be principles that it's not what they say, but what they do is really what's going on. Jack and I had a client on a mortgage deal, and she had received a notice to vacate by the sheriff after we'd done tons of work and paperwork, etc. Did that mean it wasn't working? Not at all. It was just another offer. We countered that with a nice conditional acceptance on proof of claim that there wasn't already an agreement attached here to, etc., etc. She's still in the house today. And so, if you have an understanding that, one, they always do it right, but they can test and they can play, then everything isn't always as it seems. You make the law. They need your consent. A final throw at it. And in that particular case, that was very effective. But if you can get your mind wrapped around that they always do it right, that we're usually the ones at fault, not usually, invariably, we are always at fault when we're not obtaining remedy. And it takes such there's such subtleties involved in it, what constitutes this. It's just going to take all of you a little time. It's not so evident in an express understanding. We've had a couple of our fine students go into court, and they say they do their business and walk out. Boy, they thought they were going to be arrested. They did it right. They walked right on out. Marshal puts his arms up the bottom, and the judge says, "It's okay, let him go." And it's such beautiful stories. This government, you're going to find, as a creditor, is the most perfect government on the planet. The republic and the democracy are available to you, and they don't make you do anything, but they will protect you from your own self, and you will not like that. Don? Hold on, let's put it on speaker.
What's the point of warehousing your body when they determine you're a debtor?
What's the point?
When they're beating you and giving you a place to stay, what are they getting out of putting you in prison?
Let me answer that. Hopefully as briefly as
That's a good question, by the way. What's the advantage of it? Well, there's a lot of advantage, but let Jack talk.
There is no money anymore. Lawful money is gold or silver coin with proper quantity and quality. But that was demonetized in the 1930s. So either in the republic or in the democracy, there's no definition of what money is.
Well, there's money. Because money is defined under UCC as the medium of exchange.
It's
money. There's not lawful money, though. It's a medium of exchange.
Yeah, but it's something you can
evidence. Right. Even though it's an evidence of debt, it doesn't have any intrinsic value, which is typically what people think of money. as being something with intrinsic value. It
Money
doesn't have intrinsic value other than the value that an evidence of debt has. Because we walk around with evidences of debt, we realize the value in them. Isn't a bond an evidence of debt? Or evidence of a liability, or evidence of a duty? In fact, you can sell your accounts receivable to your bank because it's evidence of a debt. It's a medium of exchange. So we use, it is a medium of exchange in that definition of money. Now, it used to be that what we used as money had actual intrinsic value. So if you're exchanging something with intrinsic value, banana, it's got intrinsic value for gold or silver, which have intrinsic value.
Okay, let me redefine my statement. If it's absolutely true, we're using it as a money, as though it existed. What I'm saying by that is money has both legal and equitable title to it. What we're using as a money represents an exchange of equity, but there is no exchange of legal title anymore. And in a strict definition, money is portable property, which can be exchanged for other property. And so you get what you, quote, pay for, and if you're exchanging only something used as money, you get equity, which means you get equity, but you don't have legal title, so you don't get legal title. And the definition of a sovereign is one who has both legal and equitable title in his possessions. So in 1930, when they got rid of money, they basically made it prima facie that there could be no sovereigns left on the planet because nobody can acquire legal title to anything they acquire. But we're getting off point to your question, why is the guy in jail? The guy is in jail because your body represents commercial energy. Money is the exchange, the currency, which exchanges commercial energy. So the source of that which is used as money emanates in a living body. A dead body has no commercial value because it cannot either by the mind or by the physical nature of the body create, convert, transport, or change any energy.
What about the bonds that are put up?
That's the commercial energy.
Yeah. Okay.
Yeah, it's part of the exchange of the energy, but in order to invoke the bond, it has to come from someone's authority and permission. And so in reality, it is your signature, the signature of a live human body, which creates that which is a commercial energy or that which is used as a money.
And that bond or instrument only has value when the asset is pledged. So the body, the asset, is pledged. For instance, if I put up a bond with a bank and it's an asset-backed bond, they'll trade these on trading platforms and earn and make more money out of it. But the backing of that bond has to be an asset that is pledged. The interest in that asset is pledged. So you must pledge your interest in the property, the body, to them. Because now that they have an interest in it, they can float these instruments on it and earn more money.
Where did they get the interest in your body?
They would print two pictures.
How did you give it to them?
Voluntarily.
Set up a trust to put it into as the birth certificate to begin with. And then each transaction you authorized it to continue to go into there. So the birth certificate created a trust with all your commercial energy, divesting the living man of the energy of his own body, putting it into this trust. So the birth certificate is a security agreement between the state and the party. And that security agreement, when registered in a public registry system, becomes a claim, a lien, or a title against the body. So if your strongman estate fails to make a payment, let's say on a criminal charge, and the strongman estate is now found guilty on that criminal charge, then there is a duty, a liability, a tax against that estate to set off that charge. Since the body is the currency or the source of the currency, when they deposit a body in a physical location, And the body is money. Isn't the deposit of money called a bank? And so aren't prisons banks? And the prisoner in there owes a certain amount of money for which his body, through the registered security agreement, ties him into the contract. And the amount that he owes is like a certificate of deposit. It has a fixed amount, good for a fixed period of time. And so everybody in a prison is in a bank on a certificate of deposit. And that certificate of deposit, those funds, that energy is tied up for a fixed period of time, which cannot be let out in circulation. So you're kept in the prison as though you are a CD on deposit. And what does the banks do with the funding that's on deposit in these CDs? Don't they take that equity out and reinvest it and make money or profits off of the reinvestment of the equity? Absolutely. If you were a banker, that's exactly what you would do.
So when you're sitting in prison,
they're making money off of the people in prison. What does Scripture say in end times? Aren't they buying and selling the souls of men?
You know, you do have that birth certificate and the rest of that stuff out there, and that is a concern to one degree. But remember, contracts are dynamic. When you try and grab me up off the street, bring it forward, if you will. You're not going to do it, so you're going to get whatever you contract for. Somebody brings you a charge, discharge the charge.
Sometime this weekend, Brandon will probably put on the chart the flow of the way things go in commerce. It goes from money or currency to title to possession. And everything they're doing in the court and everything you're doing privately in your administrative process deals in that succession. For instance, you want to buy a home. You don't have money. So what you do is you sign a note. The note produces the currency, but it's produced by the living man.
Slow down, I like this. Slow down, I like this point.
He produces the currency. What happens is the bank takes this note and they go, well, we don't want to use private money in our system because if everybody figures out that they create the money, they'll just go down to the grocery store, pick up groceries and leave a note. And then that cuts the bank out, and it cuts the government out, and nobody's controlling these people anymore. They'll just go out and buy whatever they want on their own notes. But worse yet, they won't be responsible on their own notes to go out and perform any service in society, so that their notes, in essence, are hollow, there's no substance, and people will be stealing, and the society will collapse. So the bankers go, you know, we're not going to define that note to be a negotiable instrument that's going to change hands in society as a public money. We're going to call it a security. Well, a security agreement is a contract for performance. And if you register a security, it becomes a title, a lien, or a claim.
You know, I like Webster's definition of security, and it helps you to understand it. Any evidence of debt, and it has one other to it, evidence of debt or ownership, especially a stock certificate or bond.
So what they have done now is they've taken your note, you gave it to the public, they don't want to use it, so they sell that security to the public window of the Federal Reserve System and the private DTC, Depository Trust Company, which takes it now as an asset, which is a title, a property, a claim. They then end up creating Federal Reserve notes. In other words, you gave us a title. We're going to buy it from you with money. So the exchange is the DTC got your title, which is an asset at face value of your note. They sent public money back to the bank. So now you created private money, but the bank sold a security which got monetized for public money, which is what they lent to your strawman. Now, when they lend the money to the strawman, what does one do with money? You always use money to buy a title. So the money that went out of the bank that was loaning the strawman to buy the house paid the seller of the house to buy a title. So now your strawman's got a warranty deed.
Hold up, Ken. So when you say, make it more simple, like if I'm going to the grocery store, what am I really buying at the grocery store? Help me out a little bit.
Grocery store is a perfect example. You go to the grocery store, you wheel a buggy through the aisles, loaded up with crap. If you go to the front door and walk through there, you're going straight to prison. What you do is you go to the checkout counter, right? Now, you are trying to purchase title to something, all of the crap that's in the buggy. In order to acquire title when you didn't have it, you got to give them currency. When you give them currency, you're buying title.
Wait a second, so I'm not buying the groceries, I'm buying the title of the
You're
groceries?
buying title. It's currency, title, possession.
Okay, I just need to get that.
Okay? Now, what you're doing when you offer the currency at the register, haven't they already scanned the items so that they know these are property items being withdrawn from their inventory? And so they say, well, you know, in order to acquire title to property, that'll be $75.33. So you extend to them currency. What is the next part of the transaction and what happens?
So you adopt the
They
title.
give you a piece of paper. And where did that piece of paper get printed out of? Register. See, they had title. You were negotiating an exchange, which is a security agreement. But for the security agreement to morph into a title, they have to register it in their records. But isn't that what their computer doing in their registry? Registering the exchange of the contract. You're going to offer me money, we're going to offer you some goods. Okay, there's the agreement. Now when we record it so that they can bring it out as evidence in their transactions, is actually the security agreement is registered, moving the security agreement from a mere security agreement into title.
So if I get
Or a
stopped,
claim or a lien.
so if I get stopped at the grocery store door, I don't say these are my groceries. I present evidence in the form of a title, i.e. a receipt, and I'm going to walk out of there.
They print out a piece of paper from the registry, right?
Right.
And so the clerk is now the first one to hold the receipt, right? Possession is when she gives you the piece of paper. That's possession. The goods that are down here in the buggy are the price, the premium, to induce you to come in and purchase the piece of paper. But that's the only reason you're in the store. You're there for the prize. You're not there to get this marvelous piece of paper. But the point is that you're in a foreclosure. You know, there's a lot of people going through foreclosures, and it's going to go currency, title, possession. When the bank brings the property on foreclosure, either to the trustee or the court, what is the bank doing in that action?
Perfecting the title.
Well, they're selling a title. What title are they selling? Mortgage deed or the trustee?
Well, first they have to perfect that they have the title to sell. So
They should, if people made them.
Right, but what they do is they give you a new agreement that they do have that title by initiating the action.
Correct.
By initiating the action, you have nothing but agreement with the action. You're agreeing that they have the title. Because in fact...
Slow down. I'm just a little faster. Let's slow it down.
I tend to do that. So in fact, what happens is that they're attempting to convey, okay, grant and convey title to the property. However,
Well, who has the title first?
you have the title.
I've got the title,
You've
okay.
got the title because you've got the grant deed.
Okay.
Or what Jack called the warranty deed.
But wait a minute, the other deed supersedes the warranty deed, making the warranty deed invalid until the trust.
First in line, first in time, which one was established?
But there was a death contract by way of the trustee.
I know that's what we would call an encumbrance.
That's true.
So it's a lien on the property, but it's not title to the property.
Hold on, you're going too fast for me, guys. Just go
No,
ahead.
not to say a lien is a form of title. Okay? You can have, in one item, multiple people can have interest in that item.
A lien is what? It is not a lien, just a claim on the property.
It is. It's a
of another
form of
as
interest.
security for the
It's a
payment
form
of
of
the
interest, but
estate.
if you read it, everyone whose name is on the document has an interest.
Right.
So there's the bank, there's the trustee, if it's a deed of trust state, and there's the trustor. Okay? So you have three interested parties. All three parties have an interest. Now, one of those parties, the trustor, has another interest that superseded and preceded that. Okay? Now, in order for the bank to convey its interest,
Wait a second. What's the trustor in this relationship?
trustor is the purchaser, the person who purchased the property.
Okay.
So you're the trustor, you create the trust. So again, in mortgage states, there's no trustor, but it's the person who's on the warranty deed. When the conveyance happens between the seller and the buyer, the initial conveyance. Okay? What the seller conveyed to the buyer was their interest. So you have a form of interest that lies underneath the mortgage agreement or underneath the deed of trust. Okay? So you have title and you have possession. When you have those two things, those are very hard to overcome. So what they do is they carry on a series of transactions where they get no rebuttal from you in the transaction, where they're conveying an interest. Now, all they were conveying was their interest. Well, then all they would be conveying is a lien right in the property, because that's all the interest they have is a lien right in the property. Now, if all they convey is a lien right in the property, who wants to buy that? Especially if it's clear that the guy in the property isn't paying on the lien right,
So a lien
so there's
right
no value in it.
So a lien right unto itself is really nothing. It just, you can have a zillion liens on it.
Yeah, you can have a lien, yeah. Can you enforce the lien? That's what it comes down to, because you hear about all these people who file UCC1s on their property, and then what? Nothing. Right?
Okay, Brandon's right in what he's telling you so far, but remember, we're creditors. And what a creditor wants to do is he wants to remove all form.
Oh yeah, I'm not telling you this to tell you this is the approach to settling. What I'm telling you is what's going on is the bank is they give you a trustee sale or a sheriff sale. What they convey is their interest. At that moment, though, nobody wants that interest. However, a trustee sale and a sheriff sale deed, those aren't grant deeds, and they're not deeds of trust. It's a special kind of deed. How many people heard of a quit claim deed? Okay? It's just like a quit claim deed.
Okay, there's no warranty or guarantee.
Right.
That is what it is.
So for instance, Gordon has a house. Okay? I quit claim Gordon's house to you. What did I just convey? Nothing, because I don't have an interest in Gordon's house. However, I walk up to Gordon, I pin a 3-day notice on his door, I take him to an unlawful detainer, I get him kicked out by the sheriff, now I got possession of the house. What did I just convey to him?
Possession.
Possession was conveyed by a document that happened before I got the possession. See, in a quit claim deed, if an interest is acquired later, that's what's conveyed in the previous document. So in the trustee's deed...
Hold on, I lost me on that one.
Okay.
Go back just one sentence or two. I like that. Tell us again.
Okay, so in the trustee's deed or the sheriff's deed, what's conveyed is an interest they have not yet acquired, which is possession.
So back to simplistics. It's my house, and you just out over here just came over here and gave it to Don. Okay.
I conveyed it. I conveyed my interest.
Whatever interest you had, which was none.
Which was none. But then, I skillfully acquired possession.
Okay, slow down, keep it going, I'm not with you.
So, because I skillfully acquired possession, and because I had granted and conveyed my interest to Don, the interest that he obtained was the possession that I obtained later. Okay, so in a trustee's deed upon sale and a sheriff's deed, what's conveyed is actually acquired later.
Because whatever interest you have at this time, if you don't have any at this time, you're going to go get it later.
Right, and what we'll show you this weekend is, as a creditor, that's the three elements that we approach. See, first as a creditor, we settle the account.
That's currency.
That's the currency side of it. Then, as a creditor, we're proactive in perfecting the title. Because once the account is settled, there's no longer an encumbrance on the property. So we need to eliminate the encumbrance.
So you're still going to, in simplistic, you're still going to give Don whatever interest you have in my deal, whether it's settled or not, aren't you?
Yes.
Because you still didn't have an interest to begin with. But you're going to see if you can't still get it later, right? Okay, I'm with you. Go ahead.
Once you've got the title free and clear, you've got ultimate right for absolute possession.
And because you're already in possession, that's not an element you have to perfect. However, some people are in a position where they've lost possession, right? And there's what a lot of states call a redemption period. And even if there isn't a redemption period, it's all a contract.
We could non-pro-tunk something.
You can non-pro-tunk it, but, and then so you would go through the process of, you still need to settle the account first. Settle the account.
Settle the account.
Settle the account.
Pretty simple, settle the account meaning.
There's an obligation. That security agreement.
Let me use the example of the guy that we said was in the court who had a man of character and may not go to jail, okay? What was the judge asking him to do to prove he was a man of character?
Say the IRS.
Settle the $2.5 million so that the court was saying, produce the currency.
Settle, what do you mean settle?
Produce the currency, set off the debt.
Okay.
Have the guy done an A for B, had he done a bond, had he done a draft, he could have set off the $2.5 million. Now, why were they holding him in jail, and why was he in the court process? Because they had possession of the guy's body in jail, didn't they?
In an unsettled account.
In an unsettled account, and they were using the possession to induce him to make the currency payment.
So likening it to a mortgage.
If he made the currency payment, could they give him a receipt for the debt owed to the United States?
They could.
And wouldn't that receipt then recorded in the court be titled?
Could be.
And when he released and freed up the title, why were they holding his body in a jail cell? Because he was deposited as the currency to underwrite the lack of the fact that he had made payment voluntarily on the account.
And let me demonstrate this for a way that might clarify it completely.
You guys are going so fast.
And tie it into the mortgage. Okay? Just like Jack said, there's the account that's settled, right? That account was holding an encumbrance. Let's say that court case does charge.
Use a mortgage. That's more like
I'm going to relate it. I'm going to show you how they both relate. So there's the charge, right?
Okay.
That's the deed of trust.
Okay.
Okay? It's an encumbrance on the property.
Deed, trust, or charge, same thing.
Same
right?
thing.
Okay, gotcha.
The house,
Yeah.
the bond.
Okay, yeah.
And so there's the charge, the
Yeah.
encumbrance on the bond. And there's the deed of trust and encumbrance on the house. Right?
Okay, now
You see how those two
yeah,
things
I've
are?
seen it. I'm starting to see it. Okay.
Settle the account first. Right?
Pay money.
The encumbrance.
So I got to pay something to settle the account.
Right.
Okay.
Pay something to
Pay
settle
the
the
bank
account.
what they're looking for so they won't foreclose, or pay the court what they're looking for to settle the issue behind
So
the
hold
scenes.
on, let me simplify. So in the court case deal, I got to get the $2.5 million to the IRS. But if I've got a mortgage situation and it was originally a $400,000 mortgage, there's $390 left or $400. I need to tender as full satisfaction of the claim, some kind of a financial instrument to discharge the debt.
Absolutely.
Okay, I got it.
And in both those cases, the encumbrances, there was both parties had an interest.
So over here, I can use the A for B to settle, right?
Absolutely.
Okay, just
In
clarify.
both cases.
Okay, both cases.
Both
Okay,
cases.
go on.
Okay, so there's an encumbrance on the property.
Got it.
Okay, the title of that, there's the right to possession.
Yes.
Okay?
The sole right.
We both have an interest in the house, right? Both the bank.
Yeah, I do because I signed the mortgage, right, and so on, and the bank does because they lend me the money, right?
Okay, so there's two parties with a right to possession.
Okay, I got it.
With the body, you've pledged the body as surety on the charges.
Now we're over here talking about the court case. Now we're off that, we're on this one.
We're on this one.
All right.
Okay, so there's two conflicting rights of possession. Okay, over here, you need to discharge the bank's right to possession.
And I do that, hold on, by paying them.
By settling the account and
Settling.
settling the title.
Okay, so we're just dealing with settling an account first thing.
Well, once you've settled the account, in a mortgage situation, we're proactive in perfecting the title, which you could do over here in the court case.
Okay, hold up, slow down. I understand A for B, I settled the account over here on the mortgage. Let's go to the court case, I'm taking the $2.5 million, I'm settling the underlying civil.
But understand, Gordon, what you're not looking at, that Brandon is trying to show you, is just because you paid the money, you performed on the contract, but it's a security agreement.
I'm with you.
And in that agreement, both parties have to agree that the consideration, the payment was sufficient to terminate their interest in this contract. So in order to get the agreement in the security interest, you gotta go through a process, which we're gonna talk about this weekend. The end result is when you got the agreement done, you gotta register notice of that agreement to change the security agreement into a title.
Slow down, let me just get a little bit closer here. Y'all with me? So I've got to get, hey, look. We need inquiring minds want to know. Just because you two are smart doesn't mean I'm lacking, you know.
Is it merely an unlettered man can?
That's it. No, seriously.
Yeah,
So I just need to slow down just a little bit so I can get a little bit better understanding. I do the A for B. Now I understand we got like section 1, we got settlement. We got the process, what we call an administrative process.
All right. You got to do anything that in standard commerce is recognized as a request for an order to move the storage of commercial energy from one account here to another account over there.
Simplify to pay the bill.
Yeah, it moves from your account where you're taking the units out, and it's going to put it in their account because they want to get paid.
Slow down. The units, you say dollars, units.
There is no real money, we'll just call them units, because since there's only the game of paying, there's nothing by which to pay. So you play the game as though there was money, and you say, I'm going to write a check, which is going to move them from here over to there, so you can pay with a check. But if the check is on a public account, removing liability funds, if you can reach behind the democracy into the republic and get what we call asset funds. That asset funds has both equitable and legal title, and it moves not only the equity in the contract toward you, it moves the legal title in the contract to you, and that is something you cannot do in the public because the public does not recognize that you have the capacity to move the legal title. So first they have to understand there's something that you can do, quote, to pay this debt.
But in reality, whether I use my signature in a draft or something I create, an asset-based financial instrument, or I use some liability funds, either one is going to move a title. Whether it moves
we're not at title yet, we're just moving currency.
Yeah, it's moving currency. The title happens as a separate process.
Okay.
In the interest of time, because this is actually what I'm about to say will take me hours of explanation and showing you the actual process of doing it. But in the house situation, we perfect the title. by eliminating the encumbrance by doing a series of private process and public filings which eliminate that encumbrance. We do the same thing in the court case, where we do a private process, and then through the agreement established in the private process and the powers obtained, we execute certain documents which eliminate the title that they have on the body. So over here we would have like a what do you call it? A full reconveyance, right?
Are we on the title section?
The house, you have a full reconveyance of deed. You may have, I don't know what it would be called in the mortgage state if they do. Is it called reconveyance in the mortgage state?
Is that be cancellation of mortgage?
Cancellation of mortgage.
Satisfaction.
Okay, whatever in a car situation, release of lien with the DMV.
I think the DMV just did on satisfaction of lien.
With the court, it's going to be if there was already a judgment, a release of judgment. Okay, if we're not at the phase of judgment and we've achieved private settlement, it would be dismissal with prejudice because we've already settled this in private. We don't need to have a public order or judgment in order to settle. We settled it. So, but we need to be the ones proactive in executing the release of title because we're the creditors. We're not putting the duties out there on someone else to execute on our behalf. And if we wait for someone else to do it, it may not happen. So we don't have the right to possession until we don't get our remedy.
In simplified form, that means after I've settled the account, I've paid the money, gone through my process to get an agreement that it's paid, you're telling me we're going to have to go here and do the title too.
Exactly.
Okay, I understand. I just want to make sure I have that down. So it's not like I'm going to have to be, I'm the one that's got to do all these first steps, all the second stuff, and maintain my possession also, which might take defending against an unlawful detainer action or anything else. So that's what so we got three areas, and we got the one paid. Now you're talking a little bit about title and perfecting the title, getting all of that, the reconveyance, satisfaction of lien, potential revocation of power of attorney, and anything else that we're doing in whatever judicial or non-judicial state I'm involved with, right?
Absolutely.
Okay.
And it applies in all cases, whether we're talking about civil court suit, criminal court suit, credit card accounts.
Are you saying
car loan?
Wait a second. All this stuff,
It's all
these charges are just simply
actually,
for 27 CFR 72.11?
Yeah, some of them are easier because they don't involve property and title necessarily. Like for instance, there's no interest in title in a credit card debt. However, with a car loan, there's a piece of property that's secured by the agreement, and so there is that interest. In a criminal court case, there's a bond. There's things associated with the encumbrance or liability. So there's, in some cases it'll be easier to settle, on others it will not. And actually we're taking a break, Jeff. You can go ahead and take that. So we're going to take a half-hour break. We'll be back here at 11:15.
These Creditors in Commerce workshop sessions, hereinafter sessions, are the private exchange of ideas and concepts between the providers and the recipients. The content is not meant as legal advice. The use or attempted use of any idea or procedure discussed be different as a result of unique actions or unique statements made by the parties therein, and each different acted as in these sessions. The discussion of ideas or procedures in these sessions is not exhaustive of the subjects being discussed. Many ideas and concepts that can affect the outcome of any legal or commercial procedure are not discussed in these sessions, and the fact that the recipients may not be aware of these issues may have an adverse effect on the outcome of the recipient's procedures. It is the responsibility of the recipients to understand their own transactions and to apply the appropriate and complete concepts necessary for a procedural and substantive remedy thereto. These sessions may be redistributed privately by any recipient to another recipient requesting them, condition upon the fact that this notice is provided therewith. If you have any questions, you may contact Creditors in Commerce by email at harmony@creditorsincommerce.com.
We're going to lay out one foundation you need to know. Since everything is in contract, First thing you got to determine in the contract, the parties. If we don't know who the parties are, we have a problem. Second thing you got to do in the contract is you got to determine what is the jurisdiction or the venue of that contract. What law is going to determine the details, the solutions, how are we going to resolve problems if one comes up in the contract?
And keep in mind that that is, as any element of a contract, movable.
Correct.
Because I've received public contract offers, which I immediately moved into a private venue by returning the contract privately. For instance, a summons and complaint I recently got. That's a public side contract. I moved it into the private. And the first thing I did was identify all the parties to the contract, because I took every name off of that document. Not only the plaintiff, but there were 3 U.S. attorneys named on that document. So I assumed they must have an interest, right? If you're going to put your name or a title on there, there must be some kind of an interest there. So I made my contract with the plaintiff and the 3 attorneys. So there were 4 parties besides the 3 parties named as defendants. Was I a party to that contract? No, not initially. See, I entered into the contract in my private trust capacity. My capacity to privately contract and my capacity to be the paramount security interest holder over the defendant's property.
Well, how did you move it from a public summons into the private side? What did you do?
If I'd have responded through the court, that would have been public contract.
You mean if I'd have sent an answer back to the clerk of the court?
If I'd have sent an answer to the complaint into the clerk of the court, I'd be playing in public contract.
Well, who'd you send it to then if you didn't send it back?
What I sent it to, the people I sent it to were the 3 U.S. attorneys in their private capacities, meaning I used registered mail, $21 of postage, named them personally, care of their professional addresses, named them personally in the contracts, and then the plaintiff, which is a fiction of law, United States of America, I sent it to their attorney, the Attorney General of the United States. So those were the 4 parties that I privately contracted with, because the United States is a fiction of law. It has no capacity in private contract. So I have to go through its private phase. Who are the 3 parties that must expatriate in order to serve their roles in the United States? Secretary of Treasury, Secretary of State, and Attorney General. So I went through the private capacity of the Attorney General to affect the private side of the United States.
So what'd you do? Address it to his name, Attorney General so-and-so, or just his name?
I just put his name. Typically, I don't use titles because they're public titles, unless I'm unsure of the identity of the party I'm dealing with. Like, for instance, if I'm unsure of the CFO of a bank, but I found it published somewhere, I still can't be sure that that's the current CFO of the bank. So I may put the name, who I think it is, and then put Chief Financial Officer, which would then make his successor liable on the contract. And I may even reference that in my contract, that this is, any successors, that if the current Chief Financial Officer...
Could you just put his private name in a //Virgil, Chief Financial Officer?
I'd probably put comma, like an alternate designation.
Did you consider doing business as DBA in front of his title?
You could, and there's nothing wrong with that. I didn't do it. I don't do that. I've done it before, but not something I feel necessary to do. Like I said, it's a private contract, so you can name them how you want to name them. The important part is getting their agreement in the process.
And I got all 4 parties to agree to every step of my contract. So I got to establish by consent several facts, including settlement of the contract. So that's, and then once I've completed that process on the private side, that private contract, because it's a private contract, I brought it into the court, but on the private side of the court. So nothing actually went into that court case on the public side in regards to that contract, because I did a private settlement. And then I brought the private settlement into the private side of the court case. Because otherwise, the only way I can be recognized in the public contract is under the public trust, which the public trust was a debtor. And in my private capacity, I'm the paramount security interest holder. My private trust is the paramount security interest holder in the public trust. I am neither. I'm merely the executive trustee of these trusts. So my private trust is an upper lowercase appellation of the name. My public trust is all uppercase name, and I am the executive trustee of both trusts. And actually there were 3 defendants, and I'm the executive trustee and paramount security interest holder in all 3 defendants. So in reality, these are fictions, right? Both the private trust and the public trust. I could enter a contract as Gordon Hall. Is there anyone here who can rebut that I have a paramount security interest in the property of Gordon Hall?
He might be talking about a different Gordon Hall. I don't know.
It could be. But the fact is that don't see, so often you want to get attached to the, well, the Brandon Adams, that's the me trust. No. Like I told a story last weekend. I'm doing a mastery course, Mastery in Commerce course in LA, and it's a 7-month-long course. And I was reminded of an episode of my life where when I first moved out of my house, I lived with this family. And they were a small family, you know, mom, dad, and son. And the son, when I was living with him, he was maybe 4 years old, maybe 5 years old. He was young. And he always referred to himself in the third person. He's like, Ian's hungry. Ian wants this. Ian wants that. And I, you know, it was always like kind of like a joke. Like, you know, he never says I or me. And this is one of the ways that when you read it, and this is actually a maxim, there's actually a maxim of law that identity is established in a multitude of ways. That by merely saying that you're not the name doesn't establish the identity. By saying you're the name doesn't establish an identity. But when you're entering into contract and you're asserting that you're not this public trust, and then you start referring to I and me, you've just identified yourself as the public trust. And so it'd be a good practice for all of us to start thinking like little Ian did and refer to the defendant or the taxpayer. You see? Because it's not you. And don't get confused and use those words of me and I. Well, I paid the tax. Or I filed a this, or I filed a that. Or you charged me. Right? You have to get in the idea that you're not either of these. You're not the upper lowercase, you're not the uppercase. Refer to them as separate parties from you. In my belief, there is no title I attach to me. Brandon Adams, upper lowercase is not me. Brandon Adams, all uppercase is not me. None of those appellations are me. So when I refer to them in their capacities. I'm here representing the paramount security interest holder, the private trust. Am I the paramount security interest holder? Nope. So I don't even refer to myself as the paramount security interest holder. I say, well, the paramount security interest holder has a this or has a that, if I make any assertions. Well, the defendant did this, the defendant has that, and the paramount security interest holder has a paramount security interest in the property of the defendant or the taxpayer. So I'm referring everything as third person.
Listen to
There
an
is
attorney.
no me or I.
Listen to an attorney in court.
Yeah, my client.
Because I am here today, Jim so-and-so here today on behalf of the defendant Gordon Hall. And then he refers to everything.
These Creditors in Commerce workshop sessions, hereinafter sessions, are the private exchange of ideas and concepts between the providers and the recipients. The content is not meant as legal advice. The use or attempted use of any idea or procedure discussed in these sessions, as applied to the recipient's own personal transactions, cases, or controversies, or applied to other cases, may or may not result in a favorable outcome or the same outcome as discussed in these sessions. Each transition or transaction, case, or controversy may be different as a result of unique actions or unique statements made by the parties therein, and each different act or statement in any transaction affects or may affect whether any procedure or idea discussed in these sessions is relevant to the recipient's transactions or that the outcome thereof will be depicted as in these sessions. The discussion of ideas or procedures in these sessions is not exhaustive of the subjects being discussed. Many ideas and concepts that can affect the outcome of any legal or commercial procedure are not discussed in these sessions, and the fact that the recipients may not be aware of these issues may have an adverse effect on the outcome of the recipient's procedures. It is the responsibility of the recipients to understand their own transactions and to apply the appropriate and complete concepts necessary for a procedural and substantive remedy thereto. These sessions may be redistributed privately by any recipient to another recipient requesting them, condition upon the fact that this notice is provided therewith. If you have any questions, you may contact Creditors in Commerce by email at harmony@creditorsincommerce.com.
Before we get into the trusts, the dual trust, private trust, public trust, I wanted to address what I feel is the most significant aspect of dealing as a sovereign, as it were, or a creditor in commerce. Sovereignty is ultimate authority. It's also ultimate responsibility. Recently, there was an incident where an individual who advocated sovereignty, him and his 16-year-old son shot down a couple of police officers, and the incident just got crazy. They ended up getting killed themselves. The reason why I want to address this is that there's a great number of people in this country who are taking up the arms of being sovereign, and for some reason they've got it into their head that we're here to fight someone or fight against something. And I'm here to tell you there's nothing out there against you. And that truly to be sovereign is to truly be fully responsible and to honor contract. You know, these two gentlemen were driving down the highway in state vehicle. They were pulled over, and rather than settle the account as a sovereign or a creditor would, they chose to take up arms and shoot down two fine policemen. My hearts go out to the policemen's families as well as the friends and families of the two gentlemen who, in their misguided attempts, decided that this was the route that they would take in pursuit of their freedom. Pursuit of freedom and possibilities should never be at the hands of taking it away from another. And those police officers have just as much freedom as anybody else, just as much a right to life, liberty, and pursuit of happiness as anyone else. And that's not what we espouse here.
I think it's safe to say that we want you to fight the enemy with all that you can muster. Fight, fight, fight. Have we seen the enemy?
In the mirror.
You've heard. We've seen the enemy, and it is us. or you are your own worst enemy. We encourage you to fight the enemy. That's the only enemy in your life. You are what is precluding you from gaining all the remedy in everything. This government is truly perfect. It's just off the charts. Perfect is defined not only as flawless, which we don't contend it is, but whole or complete is another definition for perfect. So we contend this government is perfect because Jack and I and Brandon do cases with students and people day in, week in, month out. And it unerringly does not fail that contract law holds true. Those that adhere to the principles, they are helping their brother resolve the matter, and I think we talk about it. There's only one reason. Is it not true there's both a public and a private trust that run parallel in today's society? Yes. Is it not true that the public has not the resources to resolve all problems in private? They can't fix everything. Is it not true that the only reason that public trustees, policemen, judges, courts are involved in the remedy of any problems is because the private parties fail to resolve it? They don't come into your life till there's an unresolved private problem. And that would be either under public law or private law. Public law dealing with individuals and the relationship to the state, with the state acting as an entity capable of being perceived as a private entity, private individual. And then private law, which is individual to individual. So, and then is it not true? If that's true, that the only reason they're involved because the private parties fail to resolve it, then once you learn to resolve and come into harmony, you're not going to have any run-in with the public, except mere little periodic testing because they get to see whether they're dealing with some of their errant cattle. Chattel, cattle, all one and the same. So, forgive me, Brandon, go ahead and finish, but we're excited for you to fight the enemy, and the enemy is never anybody else. It is only, merely, singularly, completely just you. Once you've conquered you and your ignorance, because ignorance and freedom cannot coexist. Think about that. Ignorance and freedom cannot coexist. Once you understand that, and you accept they always do it right, and you're not getting remedy, then you know the problem. It's me. Me. Not me, give me something. It's me that is the problem. And the sooner you do that, and next time you hear people whining and reviling about government, about their brother and sister, about whatever, go back to James Allen. A man only begins to be a man when he ceases to whine and revile and commences to search for the hidden justice which regulates his life. You are the regulator. You are the governor that determines the speed you're going to go through life.
And so that's the one thing I want to get across, that we've seen success in coming from a place of peace.
Weekly. Every week we see it.
There's no need to ever resort to violence, even in your attitude, because that will be something that works against you. When we have students who go into court with this righteousness or sense of entitlement, which is really something that we, as people seeking an alternative to the system as it is, we have this that's one of our natural enemies that lives within us, this sense of entitlement, this sense of righteousness. Not that it's wrong, but it is something that you will contend with and will stand in your way in getting your remedy, that you're better than them, that they're ignorant and you're smart, and you're going to explain how smart you are and what you know. So be careful in the things that you do, and be mindful that, because there are a lot of people out there who are teaching the exact same things we're teaching as far as mechanics, but they teach it in a context of those bastards. We got to get them. We got to break their legs and we got to shoot them. I've seen it being said. And if your approach is we got to go out there and we got to knock some heads, be prepared. Your head may be the one that gets knocked.
You know, you have good sense. The government has aircraft carriers, nuclear weapons, and all sorts of stuff. Now, on a serious note, are you just completely out of your mind? You know, if we're going to go get a fight, let's pick on somebody small. You know.
Let's go get Brandon.
You know, there's what you, and I know you might be kind of tough, so we might have to find somebody else. Where's Alina? Now that's somebody we could probably be assured of success with.
I don't wonder. She might.
I don't know. She might have some skills.
There you go. Yeah.
You know, the government truly is there to help you. They can't help, and they have not put some seditious, surreptitious, evil governor in government.
Have you seen the movie Kick-Ass?
Yeah.
There is a little 10 or 12-year-old girl in there that will let you out, dude.
That's why I said we got to find somebody else. So if you get it in your mind that it's pointless. One, from Brandon, Jack, and I's point of view, I like to think it. You could serve God or you could serve man. That's your two choices. Debtor, creditor. Choose you this day whom you're going to serve. If you serve God, then you would handle it the way God would have you handle it. He's told you how to do everything. How do you fix up an angry word from an officer? With a soft response. Not with a vocal, loud, you know, and understand these things. These judges, and we see it on a weekly basis. Our students are in court. We file certain paperwork, and those judges, just like this gentleman, the basketball player we talked about earlier, on May 20th, that judge for the first time treated this guy like a creditor, said nice things, was soft-spoken. They were shocked. His friends and family were shocked. And he gave him 60 days to resolve it. And at 60 days, he didn't resolve it, and he was pretty stern about his warning, and he just hung with his position. I just got off the phone with one of their friends, and they said, now I see it, now I understand what you're talking about. I said, what, you finally? She goes, oh, I can't believe we did this. You bought some hook, line, and sinker. No fighting, just harmony, ladies and gentlemen. Jack and Brandon are going to go into a little bit of this dual trust, private, public, how it kinds of works. You're going to get a little bit lost in it, some of you lay people, which is about all of us. Some of us are going to get a little lost in this. Don't worry. There's plenty of tapes in the back there you can pick up from seminars that go into this dual trust. This one is available. You're always welcome to tape these your own self. They're going to be free on the CIC site, or you can purchase some nice DVDs that go into it, kind of interesting also.
Yeah, because we also have available, everything that we have on DVD is available for free in audio on the website. All the documents we've ever put out, all available for free. When I created Creditors in Commerce, it was with the intent of getting the information out there so that no matter who needed it, they could get it. Now, the only reason I have to charge for the DVDs is because they cost a lot of money to produce, but downloads, I cover my costs on that by selling DVDs, by selling videos, and it also helps me cover the overhead of actually running this thing, which has become cumbersome in and of itself, but everything is available. And I intentionally will always keep it that way so that everything we ever do will always be available to everyone. Because the way I see it, my personal mission here is to create freedom and possibilities.
Now, if you can't get enough from the DVDs or off the site, I offer mentorship programs, immersion programs where you come down, personal training. If you have a court case, I charge for it. But if you can't get from what we talk about free enough, which is hard to do, give me a call. My number's available. Get a card from me before you depart. I work with Jack a lot. I work with Brandon, so you get all three minds rolled into one. It costs you, but the price of your freedom and these other things are learning if you need it. Education does. So give that some thought, and we're happy to help you on that basis too. Everything we talk about is free, but if that isn't enough, some personal training over a monthly kind of a program on a mentorship, or if you think you need to come over to the house and spend 3.5 days 24/7 with me, because I'm usually have you up at 6 or 7 whenever you feel like getting up, and we go till 10, 11 at night talking, living, and working people's problems as well as your own. And a lot of times it's very, very helpful to many of you because it immerses you in it. You go, God, I finally see it. Because you come to this, it might not be enough. So give that some thought.
And then remember the context of this. The reason it's interesting, I've been teaching this public-private trust ever since I first learned it from Jack, and this was before I even knew Jack. And I even did an entire class on the private and the public trust, because for me, having an understanding of the public and private trust allows you to define and make distinctions of the roles happening in any and all transactions, cases, controversies, circumstances. When you're able to define the roles and see what's going on, then it makes it very easy for you to develop your remedy.
To define a problem is to half solve it.
Absolutely.
So when he's talking to you about to define the roles, you understand your part in the play, their part in the play, apply the principles we teach, and you can get the remedy 100% of the time. Creditors never lose, debtors never win. Yes, in court you have, if I sued Brandon and we took it to a public tribunal, one of us debtors is going to win. But when the government's on the other side and they've sued an individual
or corporation, or even in I've even applied this in private contract disputes, where people who, like for instance, having a construction company being sued by homeowners or something like that, you can apply this technology and this understanding in all cases, and that's where. To me, it's so much more important for you to understand how to develop your remedy rather than take all the documents we give you and just put your name on them. That doesn't bring you any understanding. I know it's good practice. It's great practice for developing an understanding of how an administrative procedure works so that you can get an idea of how to create your record, because that is absolutely essential. As far as mechanics go, creating a record through your notary that's going to be the basis for your settlement agreement, that's probably the most important mechanic there is.
We're going to spend some time teaching you how to get your contract, the administrative process, which you've got a contract. And the other part's going to be the practical application and holding your contract. So this is not going to be, it's going to be a crammed up 3 days. And hopefully we can get you understanding the principles and concepts to obtain your agreement in writing or your record or memorial of your agreement. And then the other part is going to be able to hold it, the practical parts, and some of the stories that go along with giving it up. How easily, you heard earlier on a mortgage, how easy it is to give something up. They didn't have it. There was no money in account for that woman's payment. They created it, said, oh, we found $600 here. Well, you want us just to make it? We're going to foreclose if you don't say yes. Oh, yes. They're not doing anything. They don't own it. So let us let the games begin.
This trust document up here is on an electronic file, and I think I've got 4 electronic files back there that if you have a USB stick sometime during this weekend, you feel free to download. I'm sure that Brandon will let you pull it out of his computer.
Yeah, actually, I just uploaded it to the internet, too, so you can download it. It's in a zip file.
Well, let's just give them the file, and they can go get it themselves.
Okay. What I'll do is I'll put the URL up after when we take a break. I'll have the URL up here for downloading it.
So you don't have to take notes off this. You can just download it. We'll give you the URL in a little while, and you can do that. But feel free to... Too late. Don't feel stressed that you got to do this when Jack's going to give a nice presentation on this.
Try to be present with what it is he's presenting so that you can infuse it into your understanding. You know, it's not so much about memorizing what this chart is. It's about having an awareness and an understanding of the principles behind it. Okay, it's not so important to remember all these different boxes, but what symbolically they represent, and how a trust relationship works, and how the private trust and the public trust interact, and understanding that that's what you're doing in commerce. Even in two private contracts, in a contract between this gentleman and myself, there are two trusts, three trusts being existing in that contract. There's the private trust, which I'm assigning the rights, duties, and responsibilities of my side of the contract. There's the private trust that represents the rights, titles, responsibilities of his side of the contract, and there's the trust that's created between us, and the roles actually shift. So I want you to see and understand how even in a trust relationship, the roles shift. Like even in the commercial process, we'll be talking about a grantor, a trustee, and a beneficiary. How when the person initiating a process initiates the process and you become the holder of the process, there's a trustee beneficiary role, which when you turn it around and put it back on them, you've shifted the roles in the trust. So there's the trust I'm operating that represents my rights, titles, and interests. There's a trust that the other party's operating that represents their rights, titles, and interests. And there's the trust between our trusts, that the roles are shifting.
There's Mary Smith gets married to Jim Jones, and they now have, so you got the Mary Smith Trust and you got the Jim Jones Trust, and now you have a Mr. and Mrs. Jones Trust.
Jim Mary Trust.
Or a Jim Mary Trust.
If you look at our diagram up here, does anybody not understand what a trust basically is for or what it does?
You better explain it because we don't know.
Okay. We start in box 1 as a living man or woman. As that capacity above the line, which is in the private trust, which is the republic, it's the law of the land. Law of the land is a natural environment for man, and you're free to go about God's creation and do whatever God inspired you to do with the gifts He gave you. If you don't like what's going on around you, just shift over a ways and do something else. Below this line, you're in the public trust, which is Admiralty Maritime Equity. It's like living on the high seas. Living on the high seas is not a natural environment for man. It's non-natural. Man cannot live on the high seas unless man has underneath him a vessel to keep him afloat so that he will not perish in the water. When you're on land, you have unalienable rights. When you're on a vessel on the high seas and you share that vessel with someone else, one or more, two or more people, there is someone that's in control of that vessel. It's called a captain. That captain has the power of life and death under the law of the sea. And you are in rebellion or mutiny against that captain if you do not follow his orders.
That's because your compliance and your behavior affects the safety of the whole ship. So it's not you've somewhat given up your rights when you go on that ship.
The importance of that vessel is to sustain the life of people. But if the vessel is not seaworthy enough, or conditions exterior, the weather, the waves, present some kind of possibility of the vessel being overwhelmed so that it will not stay afloat, it may be necessary for the captain of that vessel to make some very difficult choices and orders. He may have to throw your property overboard, your valuables. he may have to throw you overboard because if the boat is sinking and we're going to try to keep it afloat to get as many lives to shore safely as possible, we may have to sacrifice other lives. In the case of the Titanic, when the vessel is going down and we have a limited number of lifeboats, the captain will determine who is going to be saved in the lifeboat and who is not. And so you lose rights and remedies when you're on a boat on the high seas. So Admiralty Maritime is not a natural law environment for every man, woman, and child sustaining all of his rights and remedies. There are times in history and conditions of society that the law governing people, even when they're on the land, they are being governed under the principles of Admiralty Maritime equity. And so those rules come on board to govern people who even supposedly are in the reality world of being on land during those times. And it's very difficult for people to understand why things that are done under Admiralty Maritime are opposite of the way things are done under common law, and yet why are they still being done on the land to me? For instance, under the common law, there is a maxim or presumption that in a criminal case, you are innocent until proven guilty. In Admiralty Maritime equity, the maxim is the mirror image. You are presumed to be guilty unless you prove yourself innocent.
Rebut the presumption.
Since 1933 in America, we are absolutely under Admiralty process on the land in our nation. We're not going to spend a lot of time developing the history of why that is today. What we want to do is give you the foundation of this trust. If you want to go back to some of these history issues, I think we probably got them online through LA, through probably Texas, Dallas, and Chicago. What we want to do is show you what's going on today. Now, when it comes to a trust, if you're operating in and of yourself and you have title both to the law title to your property and the equity, it's in you. All you are is block one. And on the land, you can exist in commerce as block one, having total legal title, total equitable title to everything you possess. But remember, above that line, we're using lawful money so that the money by which you acquire this property also has legal and equitable title.
You went a little fast for me. This legal and equitable title, could you spend a moment on that?
Legal title gives you the ability to control the property. You can make the rules for how it's being used. Who's allowed to use it, under what conditions.
Would this be like a state when you buy a car? There's a title or an MSO, MCO. The state gets that, and they technically get the title to it, or what you're referring to as a legal title. Then they can say, keep the tires up, register it, keep insurance on it, that kind of thing.
Yeah, we'll show you how that became a trust in a minute. That's a very good example. Okay? But if you have legal title, you've got control. You also have the ability then to convey the property and sign off on the deed, turning it over to another party. If you have the equitable title, you have the right of use and possession of the property, as long as the use and possession is in harmony with the legal title holder's instructions for how you can use and possess the property. So if you control both legal and equitable title, you can do whatever you want to with your property.
Is that sometimes,
nobody can tell you anything different.
Is that sometimes referred to as complete or full title?
Full title, or if it's land, allodial. They can't even charge you a tax on it.
But most, so you're saying like when you have a allodial title, there's no tax, it's held free of any encumbrance.
No zoning codes,
but
no building
if you're
codes.
paying property taxes every year, it would be safe to say that I only have equitable possession and I do not have legal possession because I'm paying a yearly rent on that in the form of taxes.
You would not pay anybody else for the use, the privilege, or the title if you had it all, but you don't.
I heard that's fee simple or in feud or feudation.
Okay.
So all of you that think you own a home or own a car, and you're paying registration fees yearly to use it on the street, or you have a home and you have property taxes to pay, you're dealing with what he's talking about, which indicates a trust, divided title, the legal and the equitable. Remember, possession is 9/10 of the law. Where's the other 1/10? That's in the legal. And so he's talking about in a trust, you take something and you divide the title of it. Just like the car, just like the home.
So if you don't have all the title in you, it is split between two or more parties. It is now a trust relationship.
Because you're trusting somebody?
Basically, trust is a split title. The equitable party is the beneficiary, which is shown up here in the top in Block 3. He's got the equitable interest. He's got the right of use and possession of the property. But the trustee, the legal title, he's in Block 2. He gets the ability to control the rules and regulations for use and possession of the property. So if you do not have full title, the property is now in a trust of some kind. And so what we're seeing going on here right now is this diagram has shown what has happened to your interests in property which you think might be yours since the 1933s in America. And around the world, this model is in full force and effect in all of the commercial modern nations of the world. Remember that the motto for the First and the Second World War were the war to make the world safe for democracy and the war to end all wars. What they were telling you is the following. Isn't a democracy a military government? Absolutely. And a military government is operated under Admiralty Maritime Equity, which is below this line. It's the trust below this line. So when they told you that the World War was the war to make the world safe for democracy, they told you, we're going to fight a war and we're going to kill people so that we can be a military world instead of a republic. Is that what everybody went to war to do?
Well, you know, World War I that he's talking about, think of what happened there. 400-year-old Habsburg Empire was dismantled. And, of course, in England, the sun never set on the English Empire. England is hardly a major dominant force anymore. Democracy is.
The war to end all wars.
World War
A
II.
nation cannot engage in war unless they're sovereign and can declare war.
Insolvent.
So since it was a war to end all wars, obviously it wasn't to go to peace. That's not what the public does. The public induces warfare and objection and complaints all the time. So what they were telling you is we're going to go to war to make sure that no nation remains sovereign. Is that why you went to fight in the war? And die so that we would get rid of all the sovereign nations? Sounds like a very altruistic reason to go into a war.
You're at war today. It's called a mixed war. When you go to Webster's, you'll find war is a very interesting definition. What he's talking about, World War I and World War II, are open hostilities. But war is also defined as any active contention, hostility, struggle, etc. Are you in an active hostility, struggle, or contention with this democratic or democracy? That you are. They're taxing you for a good reason.
Since the Second World War, they have achieved success. There have been no wars since then. Everything is police actions. A police action is not a war, and it's not intended to win anything. In a police action, the police are sent out to quell some form of physical unrest. We are not there to make sure side A wins over B or side B wins over A. So most police actions since the Second World War have ended up with no winners. They just go on for a period of time, and then they kind of wind down, Everybody goes home, or we keep a police force in position to maintain a quasi-peace, and that's what we've seen in history since that time.
Quasi? As if?
As if it was peace. So what we're showing here now is that strategy has changed for the way we have to operate in the world since these conditions have gone down. In the public sector below that line, we recognize that the public is operating under Admiralty Maritime Equity, which is not peace, it's quasi-peace. We're maintaining the so-called provisions of not open hostilities as much as we can. But it's certainly not at peace. What we're seeing above here is that since lawful money went out of existence, since 1933, if you exchange property with Federal Reserve notes, you only have an equitable interest in the Federal Reserve note. In reality, if the military takes over a nation, the first two casualties are the following. Number one, when the military takes over, they gather all the money and put it in a warehouse. Gold and silver are gone. Then they issue what's called war scrip. It's a military-denominated money. It has serial numbers on it so that they can track the war scrip. Why are they tracking the money? Because the commercial money can be used to oppose the military occupation. And the military government wants to track all of the spending of commerce to find out who are supporting the military occupation and who are not supporting the military occupation. So the Federal Reserve notes were issued when all the money was taken in and put in a warehouse, and they issued military war scrip. The second casualty when the military overturns a land is the truth. Because during the military occupation, they do not want to tell you the truth because you will use it against the occupation. So truth is the second casualty. So how do we know when the newspapers, the politicians, and all of these entities in the public are lying? When they open their mouth or when they publish their documents. Because that's what the military does when it takes over a nation. Now, if you are in a land of illusion, which is the land of untruth, where the military took over, where would you get the truth from? Well, you cannot get it from any of the organizations that are sponsored and promoted by the military because they're out there to tell you a lie. Unless, of course, they're telling you that they're not telling you the truth. If they tell you, we're not telling you the truth, and they're in the military, democracy, they've got to be lying, so they are telling you the truth. Doesn't that make sense? In a crazy kind of way? And so what entities exist in our society today that tell you that they're not telling you the truth? Hollywood. Doesn't every movie say any relationship to any events or any people living or dead are truly non-existent? So the only one that reports to you that they're lying to you is Hollywood, so they're about the only one telling you the truth. Aren't the churches 501c3 corporations? So the churches are part of the military democracy and cannot tell you the truth. So when do you know the churches are lying to you? When they're speaking at you. Is what they're saying a lie? Not necessarily. They can lie to you by not telling you the whole truth. So many of these organizations will give you some truth, but not the whole truth. If you don't understand the whole truth, it's a lie. You don't know what's going on. So with that background now, because we cannot operate as Block 1, because we don't have full legal title, because we're using Federal Reserve notes, they took legal title away from us. All we can do when we spend that money is acquire an equitable interest. So that means that when we come across property, we are going to have either legal title or equitable title, but we're not going to have both. It's got to be split up. And because we only have one side, if the people cannot prove full title, who has the other title by what legal theory? The government acquires the other title under the principle of escheat. Escheat means you can't prove legal title, so they take it by presumption and assumption. What we're seeing here is that in order to induce you into voluntarily consenting to get into this trust, they had to get your permission. If you go back to the Articles in Amendment, there are two 13th Articles in Amendment. There's an original, and then there is a second one which appears on the books today. The second one that you see on the books today says something like, there is no involuntary servitude except as a punishment for conviction of a crime. Which, to say it another way, is any time the government wants you to do something, they got to get your permission. Otherwise, it's involuntary servitude. In terms of history, here is how it applies to Admiralty Maritime Equity. Ordinarily, Admiralty is on the high seas. And it used to be that if countries or if corporations wanted to put a vessel out on the high seas to do commerce, they would have to hire on a crew to work on the vessel. They would have to sign the crew on the land to get their permission to work on the vessel before they would allow them to walk up the gangplank and work on the ship. Voluntary servitude. They could not come onto the land, grab people, and force them to work on the vessel. And so today, since everything we're going to see that they do in the courts and in commerce under the UCC is under Admiralty, it's absolutely mandatory that they get your signature or your consent on every program that they want you to assist the government on. You have to sign tax returns or they're not valid. You have to sign permission slips for the children to put them in school, to apply for a birth certificate, to get a driver's license. Without your signature, there's no voluntary consent. They cannot compel you to do it. So we're going to understand that and use it as part of our commercial remedies. And understand they need us. We don't need them. They need us. We are the creditors. Unless we act like the debtors. So with this background then, what happened is they knew that the title had to be split up, but they had to get our consent to do it, otherwise it's theft. So what happened is they wanted to be able to take the assets belonging to the people and use them for government purposes. And they needed your consent to do that. They started out in 1787 at a constitutional convention because the national government was bankrupt and couldn't pay their bills. So they went into a secret convention and they came up with the Constitution. The definition of a constitutor is one who passes on his debt to a third party. So the Constitution, under Article 6, was merely to make the states sureties or co-signers for the national government's debt. That was approved by the states in 1789. So in 1789, the national government in commerce was bankrupt and the states became their sureties. Could a bankrupt entity be sovereign? No. So the national government was not sovereign from 1789 on. They act sovereign. The states, under the Constitution, became the sureties to pay any debts the national government couldn't pay. When was the first time that the provision of the Constitution was invoked? 1933. FDR said, we're bankrupt, we need the states to bring in their assets. FDR met with the governors in January of 33 and warned them in a month and a half, 2 months, when I come in to taking the oath in March 5th, 1933, I'm going to call upon you to bring in your assets to underwrite the national debt. Now, it's one thing to have all of the assets of the states underwrite the national debt, but don't you think the people's assets are much greater than the assets just of the several states? You bet. But the people aren't under the Constitution. So the Constitution did not provide a legal or lawful method of getting the people to donate their assets to help underwrite the national debt. So they needed another scam. The scam is called the birth certificate scam. Because in the birth certificate, your mother pledged all of the future assets and estates of the child into a trust in the name of the child, with the child's name in all cap letters. That became the Social Security Trust in the name of your birth certificate, kid, and it was recorded in the public, was it not? Remember, when Mom signed this birth certificate application, it became a security instrument, a contract between Mom and the parties, the hospital as an agent for the state government, whereby Mom said, everything my son or daughter does in the future, every dollar of money they make, is going to go into that trust and not to them. And the trust security instrument was recorded in the state, which is in the public, bringing the birth certificate trust below this line into the democracy, not the republic. What was the purpose of that trust? So that the beneficial interest, all the collateral, the equitable value up in box 3, could be pledged to the government to offset the national debt. Who was the custodian of that equity? The alien property custodian. Why is it alien? Because the property is going to be used to finance the public trust below the line, which is in the democracy, which is foreign and alien to the republic. So just like in the Constitutional Convention, the national government got the states to underwrite their debt, in the birth certificate scam, they got Mom to pledge all of the people of America to use their estates to underwrite the national debt. And they put those assets in the control of a trustee called the alien property custodian, who happens to be the Secretary of Treasury, U.S. If you look under Title 22 of the United States Code dealing with foreign private entities, you'll find out that the Secretary of Treasury, U.S., the Secretary of State, U.S., and the Attorney General, U.S. have to expatriate their corporate U.S. citizenship below the line to take those positions. Did any of the people of America elect any of these 3 officials? No, but you see, those 3 officials are the guardians of the republic above this line. They're the guardians of all of the living men and women in America and the guardians of their estate. But they have to expatriate from this corporate so-called government below the line because there's a conflict of interest. Those guardians above the line are protecting the property of living people. Below the line, we're dealing with fictitious corporations for gain and profit. Remember, it turns out that about 2 years ago, in 2008, in September, didn't President Bush wake us up one day and say, oops, we got a problem in our economy? And he said, there's a meltdown in our economy. And we need to do something right now to protect that. And didn't they start this TARP project? And who was it that was handling all the money from the TARP? Secretary of Treasury. Did Congress have to approve that? No. Where does Congress operate? Below the line, in the public trust. They have nothing to do with any of these things above that line. So the Secretary of Treasury was given about like $750, $800 billion. Congress didn't have to approve it. Where the hell did it come from? Came from the value of the equity in your estate being held in Box 3. And it was already under his control as the alien property custodian. Now these were, quote, bailout funds, right? Who was he bailing out? Did he bail out you or me? Who did he bail out? Where would they be on our chart? Below the line, a grantor in a trust is one that places collateral and property out there to be used by the trust. The grantor is the federal public side of the Federal Reserve System for America. For every other nation, it's the central bank in that nation. And so what the Secretary of Treasury Paulson did is he put the money into the public side of the Federal Reserve System. Who is the public side of the Federal Reserve System? The major U.S. corporate banks that are partners in that venture. So he bailed out the banks, the grantors of the public trust. Now, when you're in a trust, who's got all the power in the trust? The grantor. And who does he give that power to? The trustee, who takes orders from the grantor. So Paulson provided the funding to the public side of the Federal Reserve System, who are now free at their discretion to divvy up the funds and send them on to the trustees. The trustees carry out the wish of the grantors for what purpose? For the purpose of the beneficiaries. And so who are the trustees in the public trust? Well, let's go to the beneficiaries first. The purpose of the public trust is to provide goods and services for all the equitable shareholders of the venture, which is the straw man. It's your debtor side of your trust. It's the U.S. citizen residents. Plus, it helps establish and benefit the infrastructure in this public trust to provide those goods and services to the beneficiaries more expeditiously. The trustees become the elected and appointed so-called government officials. It also includes attorneys, because attorneys are titles of nobility working for the British Accreditation Registry System. They're operating under the Crown of England as esquires. What the hell has the Crown of England got to do with it? The Crown of England, Queen Elizabeth, she's the one that owns and operates the Social Security system, which is the system for all the beneficiaries in Block 6. So we're still United Kingdom entities in commerce, even though the nation won the political war back in the 1780s and 90s. We're still under England for commerce. But then didn't Mel Gibson's movie The Patriot tell you that? If you were to go to apply for your estate, which is being held in the DTC, so you could privatize that back to you, you would have to confess that you are a United Kingdom entity to qualify to get your estate back. The sun never sets on the British Empire. Didn't you learn that in the public fool system? Wow. That military government must have been telling you lies again. Imagine that. Now, yes, ma'am, you need a mic, which means we need a mic runner, which we have.
Hi.
Hello.
I must have missed, you said that the Queen owns our Social Security system.
She is the head of it.
Head of our Social Security system?
Absolutely. Treaty through Puerto Rico.
Okay.
Yeah, isn't Puerto Rico a U.S. territory? So it's part of the 5 mile square. It's operating out of the District of Columbia, not the states. And income tax is most likely out of the Philippines Trust. You know, they've done everything internationally, and you don't understand what's happening. You're looking domestically. All these things are happening internationally, is what's going on. Okay, if you look at what's going on here, the living man or woman is associated with block 1, 2, and 6. The public officials and government are box 4, 5, and 3. Isn't that kind of a mirror image? I mean, one goes this way and that one goes that way. They're perfect mirror image, aren't they? And everything operates through 2 jurisdictions, private and public. Do you think in a heartbeat the public would continue as a viable commercial program without the financing from that private trust? It would die and has almost collapsed in the last 2 years. Without the private trust, it's toast. Now, most of the patriots say government is wicked, terrible, and awful, and full of crap. And they keep fighting the government. When they keep fighting the government, what does the government do to the benefits of their straw men? Cut them off, cut them away, seize them. Last resort, kill them. You still want to fight the public trust when that's what's keeping you alive? Do you not understand that if these two not work in harmony with each other, one or both are destined to be destroyed? And at this time, if we destroy the public trust, what's replacing it to provide benefits for us? You got to understand these people are not at war against you, and they're not against you. They have given you a structure to work in harmony with them, and if you don't work in harmony with them, you're toast, because they got more guns and more power than you do. Look at it this way. We said that you are the living man or woman, box 1. And if you could just live in that capacity, you could enjoy life and be totally responsible for yourself. Whatever you create, you get to consume, right? Look what they did to you. Here is you, 1. Instead of being 1, you are now collectively box 2 and box 6. In box 2, you're a trustee in control of your life. In box 6, you're the consumer and can enjoy all your estate. They just inserted box 3, 4, and 5, which was the government, between you and your remedy, so that you had to deal through the government. Why did the government insert itself between you and the enjoyment of all of your property? Because you were incapable of being a creditor in commerce. You did not understand how to operate your life without harming yourself or others. So they inserted some boxes of government officials through which you've got to filter your existence in order to get your own benefits. But in the meantime, they're consuming a lot of those benefits from you because they have to step in and do this. Would it be more efficient if we could cut out box 3, 4, 5, operate through 1, 2, and 6, and then say, well, if we're 2 and 6, we can just forget those and go back to box 1. And we'd be right back to where we should be if it was pre-1933. But that's not what happened. So we got to understand we're stuck with box 3, 4, and 5 for the time being. And if we can learn to operate in this capacity, be in box 2 and stay in control as a creditor to pay the bills of our straw man in box 6, that's what Brandon and Gordon and I have been talking about. Box 6 is a debtor. It's your straw man. But it's the only thing in public that exists in this public economy that appears to these people to give you a remedy. And if you don't go through your straw man to get your benefits, they don't see you as anything else and your benefits are cut off. But your straw man is a debtor, and he cannot pay any of his bills. So what you have to do to understand the cooperation between 1, 2, and 6 is when box 6 gets a bill from anyone. Does he get a traffic ticket that's got to get paid? Does he get a utility bill? Does he get a food bill? Does he get a IRS tax bill? He can't pay them. He needs to send the information up to his creditor and tell his creditor, hey, look, you're in the private world. You are a creditor. You set off these public bills. If we just learned how to do that, we could operate in this system from now on. But the problem is if the debtor in box 6 does not allow the creditor in box 2 to set off the public charges by the private set-off that we were discussing this morning, public debt keeps accumulating in the public world, and that debt gets so huge that the public can no longer operate and the system clamps down and closes. That's what's happening now. And it's because people think they're box 6 and they think they can go to their public checking account and pay their bills, and it's a novation which is creating the public economy shutting down. They said the same thing in The Wizard of Oz. Dorothy had a problem and she had the lion, box 1. She had the Tin Man, box 2. And she had the Scarecrow, box 6, the Straw Man. Tin Man was the tax identification number man that had the account to set off the credits on the bills. And what was the problem with the Scarecrow? No brain. That damn debtor kept trying to pay bills with liability instruments. What was wrong with the Tin Man? Number one, no heart. He didn't care if the bills got paid or not. And his signing arm was rusted up. If he couldn't put a signature on a 3-party draft, he couldn't transfer the funds to set off the debt. And since he never had to do that, his signature arm was rusted up and he couldn't pay bills until Dorothy oiled him up. What's the first thing do they teach your child to do in school? Definition of child is someone who's dead. Why is he dead? Because they're a straw man in box 6. All you have in the public is dead things. The first thing they teach your child to do is print and sign his name so he can give credits to the government. Government needs them to sign their name, turn over their assets. After that, don't care if they're smart, intelligent, or know anything at all. That's all we need them for. So aren't you beginning to see that in this structure it's starting to tell you what the roadmap is? You're playing three different roles. Box number one is the underwriter. That's the spirit. Box number two, that's the surety. He's the guy that is the myself. Box number 6 is me. He's the principal. He owns everything and has a liability. The only reason box 6 signs anything is to acknowledge debt. He can't pay anything, but he's the receivables for the corporation. Oh yeah, I got all these benefits, and so they go, okay, you owe. Well, I'll try to pay. Oh, I don't know how I'm going to pay. You try paying, and it's not a discharge, it's a novation. You're substituting your personal debt for the debt of the collective public. If the collective public is paying your debts, isn't that called insurance? Who's in control? The party that owes the debt or the insurance company that pays? The insurance company that pays. So you're trying, you as the straw man in box 6, you're trying to pay the debts that come to you every month. But you're using Federal Reserve notes. So you're not paying a damn thing. You're making a payment for the insurance company. So who's in control of your life? You or the insurance company? The insurance company, which is the Federal Reserve System. The grantors are in control of your life because you're using insurance premiums to pay off your debt. You haven't paid anything yourself in your life ever, probably, unless you did an A for V and got it to stick. So we're all debtors out here. We're learning to go back up into box 2. Now, the Secretary of Treasury there, he's the guy who is the one who is the fiduciary, the trustee over your estate. He has 3 international agencies working for him, none of which belong to the U.S. corporate government. They are the DTC, the FRB, and the IRS. Depository Trust Company, 55 Water Street, Manhattan. Building is called the Tower of Power. It contains all the securities or the corresponding bank's version of the securities of all valuables in the United States of America and most other countries in the world today. Canada's in there. Australia, New Zealand are in there. Yes? Is that owned by the Crown too? Put it on the tape.
Is that... Hello?
Hello?
Is that owned by the Crown as well?
Well, let's see. Canada, is that part of the land that the sun never sets on the English Empire?
No, I mean the DTC.
DTC is what?
Is DTC owned by them?
DTC is a private international corporate business.
Okay.
They're in the business of buying, selling securities. They are part of the DTCC, which is the Depository Trust Clearing Corporation. They clear and list securities on the public markets. Okay? The Federal Reserve Bank, are they part of the U.S. government? No, they're neither federal nor are they reserve. They are a bank, but they have no lawful money. How about IRS? Is Internal Revenue Service part of the U.S. government? Oh, hell no. Who is it that the IRS is part of? United Nations. They're all part of the international private corporation. Are any of these international corporations, are they attached to any nation? No. Have they been elected or appointed by any peoples anywhere in the world? No. They're called a shadow government. They're a shadow because nobody's elected them or appointed them, and they have no landmass, and they have no citizenry. But they stand between the estates of all the living people and the things that appear to be nations. Appear to be nations. Box 4, 5, and 6 collectively becomes what we know as the United States. Isn't the United States, by a definition in the U.S. codes, a commercial corporation for profit and gain? Federal corporation. Is it a government? No. Do people elect government officials to that entity? No. Who are the people that voted elections today? They're stockholders. How did you get to be a stockholder? When your mom created the birth certificate, you have a share in the corporation, so now you've been issued a share, a voting share. When you voted elections, local, state, or federal, what are you doing? You're voting for other stock proxies. The proxies are elected to go down and influence the board of directors. They're all private. And who do the board of directors work for? The stockholders of the corporation, which is you. Oh, wait a minute. The corporation is insolvent. Oh, well then who does the stockholders or who does the board work for when the corporation is insolvent? The creditors, which are the international shadow government. So you elect all of these people to go run the corporation for your benefit. And as soon as they get there, who are they working for? The creditors. They're not working for you. Does that start explaining that there is no political remedy? Doesn't make any difference who you elect. Doesn't make any difference what they promise to you. Because when they go show up, the board of directors go, well, you know, we got to work for the creditors. We can't work for the people that put us here. So why are you wasting all your time? Let me show you what's going on and what's likely to happen in 2012. Haven't we had some problems in the economy in this thing below the line? Yes? Where did the problem start? Which block? 4? I don't think so. Wait a minute. The problem's in the public trust. Everything is our problem because box 1 is supposed to be responsible. Obviously, today with the information you now have you been acting responsibly in your capacity of knowledge any time in your life until you understood what was going on today? So nobody has been operating responsibly, which is the point. Everybody has erred and gone astray. There's not one guy that's good. But in the public sector, just below the line, where did the problems in the economy today start? Box 4, 5, or 6? How many say 4? How many say 5? How many say 6? Didn't it start out with defaults on consumer debt in mortgage payments, car payments, and credit card payments? And so the problem in the economy started in box 6. The principals were defaulting on their loans. Now, is it their fault? Okay, whose fault is it? Who set that up? The people that set that up. Who set that up? We're not on a mic. Our mic runner must have fallen off the map. Oh my God. He probably went to the hospital with a heart attack. I'm sorry. Go ahead.
It occurs to me that the way it was set up to deregulate the lending practices and allow anyone to borrow as much as they could breathe on a mirror that set up the failure of the straw man.
You're telling me there was a structural failure in the architecture of the public trust so that it was deemed that the principles would fail.
I'm also saying that I think it was designed.
Entirely.
I think it's designed to do that.
Absolutely.
Okay.
On many fronts. Number one, they took the jobs away from the Americans. So what makes you think if they have no jobs, they're going to pay their principal debts? I don't think it's going to happen. Okay? So number one, they were structured to fail in that extent. Remember what Rush Limbaugh and what all of our conservative friends are saying, that the reason for the mortgage collapse was that Congress, aren't they a part of structuring the architecture of this system? Specifically made it so easy and demanding on the banks to loan money to deadbeats who would never be able to pay their debts 10 years ago, that it was structured to fail. And so I'm not saying that the people in box 6 are the cause of the failure. I'm just saying that the failures in our economy are starting in box 6 because it's the principles that have not in any way, shape, and form. He's bringing me my Coke. If I don't have my Coke, I could die. I gotta have some kind of a... Oh, man, thank you. So the principal debt load started crashing in box 6. Then, 2008, September, what did President Bush say was happening in our economy? Nothing? Melting. What was melting down? Financial. AIG. Who the hell is AIG? Insurance. They're a surety. Who are they insuring? The principals. They're not insuring the banks. They're insuring box 6. So the insurance companies are part of the public trust. They're in box 5. So first we're having a meltdown in box 6. They can't make their payments. Now the president says we're having a meltdown in the supporting institutions, the trustees, the AIGs, the insurance. AIG, of course, is some of our prominent government officials of the past that stepped into that position in that cozy little thing. And they were an insurance company, and how much did they have in reserves? Nothing. Because Congress deemed that they were so important they didn't need any reserves. Congress exempted them from reserves. Do you think that structurally led to the fact that they're going to collapse and not be able to make any payments to help anyone? So is it being designed for 4, 5, and 6 as a system to fail? Or is this just an accident? It's being designed. Who the hell would do that? Somebody doesn't want that public trust to exist. They don't want them to make it in the long run. What is the name of that public trust? The United States. The United States is not supposed to exist. It's structurally designed to fail. And so they had to come with the TARP funds to bail out AIG and the sureties. These people are the principals. These people are the sureties. These people in box 4 are the underwriters. So for the tape, box 5 is the surety, box 6 is the principal. We're having failures in the principal, box 6. In September 2008, we're having failure in the sureties in box 5. And about 2 months ago, Secretary of Treasury Geithner went over to Europe, and he went over there because what did the newspapers tell you was happening? We are having a new level of failure. What is it called? Sovereign debt failure. What the hell is sovereign debt failure? Box 4, the underwriter, the central banks can no longer sustain the sureties and the principals. Why was Geithner in Europe? Because he was allowing the United States Federal Reserve Bank, central bank, to extend overnight loans to the central banks in the countries in Europe who are in distress because of the failures along this same line in Greece or in any of the pig nations. Portugal, Italy, Greece, and Spain, the pig nations. So now we have failures at box 6, box 5, and box 4. If we have a failure across every box, what's happening to this entity called United States? If it can't sustain itself, it collapses. If it collapses, what happens? It's taken over by whom? The creditors. Who are the creditors? Shadow government. December 2012. Shadow government takes over all the collapsed corporations in the world. What's the only thing left governing the universe? Shadow government. Oh, they're probably going to keep the boundaries and the lines, and the idiots that have no clue what's going on other than more pain are going to be told, oh, there's a change in the way we're running United States, Spain, Canada, all the other nations of the world. There's a little bit different, and some things are going to happen now, but for all practical purposes, you're still United States citizens under a total collapse. So then Congress is going to be dictated what they're going to do. They have no power to do anything anymore for anyone except what they're told by the shadow government. Who gave that shadow government all that authority? The people did. It's coming out of our private estates. So why the hell are they operating the world instead of the people? Because you don't know who you are and you don't stop them. Because you see, they have control of your estate. And your estate has been abandoned because you aren't going to get it back again. And if you don't get your estate back again, then that shadow government is your trustee to protect your future from you because you're ignorant, you're stupid, and you don't know you have an estate, you can't get it, and you won't run it. But they're going to treat you not as box 1. They're going to treat you as a slave under box 6 because you don't know who you are. Now, hasn't Obama told you a couple of weeks ago? He said, boy, I don't know why you people are upset with me because I'm doing everything I told you I was going to do. What, did you think I wasn't telling you the truth? Then he said, boy, if you like what I've done so far, wait until I'm going to tell you what to do next year. What the hell is he going to tell us to do next year that he thinks we're going to get upset about? Well, what is his opponents telling Obama right now? Obama went to the G8, G20 here, 2-3 weeks ago? What was Obama's story at the G8, G20 that was different than everybody else's? What did Obama tell those people to do to their economy? Huh? Not lower debt, flood it with capital. Expand your government. Now is no time to cut back. People are hurting. What do the Republicans keep doing to his projects? We won't vote him in unless you make sure that it's not going to increase the public debt. So they're stopping Obama from expanding. But if you read Wall Street, you'll find out that public expansion really creates no new economy and no new jobs. So he can expand the public government all he wants, and he ain't going to put anyone to work. You got to do it in the private. So what is he going to do next year that he's promising? He's going to start bringing back the expansion. Why is he going to do that? Because he's going to listen to you that said, oh, we don't want any new debt because that's going to create problems for our kids down the road. So he goes, okay, no new debt. So the government's going to stop the expansion. there is no equity left in box 3 to do any more TARPs, any more bailouts. They've taken all the equity on your assets. And whatever you haven't liened, they now have liened secretly in the background. So if you've got a home that's paid off, I got news. They got it totally liened up on public debt. They just didn't tell you. It's an admiralty lien. It's secret. You don't need to know that. The reason that they can't sell cars, they can't sell homes, they can't put out more credit cards is because they need collateral to lien as a security on the loans. And since they've liened up all the collateral with TARP, there's nothing left to lien. They cannot loan one new dollar unless somebody comes in and pays off a lien on whatever they've already got. So next year when the government stops spending and they raise taxes to pay back the creditors, your standard of living is going down. But that's what they're telling government. Don't sell our children's future with more debt. So be happy. Are you beginning to see that there is a big problem that nobody is understanding? So what the heck is going to happen then? See, what they're going to do is they're going to collapse these things, keeping them there, and the one world government's going to take over. Now, what is your remedy? Your remedy is to get your estate back from the DTC. Because if you don't, your estate, isn't the purpose of your birth certificate to underwrite that corporate debt? Just like the Constitution, the state's assets are underwriting that corporate debt. If this entity, box 4, 5, and 6, are put into the disability of an economic collapse, what's going to happen to all the assets pledged to underwrite it? They're going to get seized and they're going to be given to who? The creditor. So your birth certificate assets, because it's a birth certificate which was pledged to underwrite that debt, they're going to consume all the birth certificate trusts and pay out the international bankers. And your estate is gone. It's history. You're not going to get it back.
I had a question before. First of all, 2012, where does that come in? And how does getting all of our Social Security cards and all of that stuff, how does that put us into a position
2012 is redemption for perfect government. It's also in, I can't tell you how many worldwide predictions that something is significantly changing. I can also tell you that the United States came out of its third sequence of 70-year international debt in 1999-2000. I can tell you that that was a jubilee year in which we were supposed to get back all of our assets. I can tell you that the Clinton impeachment was the national vote to roll it over pursuant to Exodus 21:5 and become a voluntary slave for another 70 years. I'm sure you understand the consequences of everything you did or didn't do over the last 10 years, don't you? No? You don't understand what you're not doing and doing? Then what the hell's wrong with you? You guys must be debtors in box 6. If you're not a creditor and competent enough to handle your affairs, you're going to be a prisoner on the plantation digging ditches in China for the creditor in a couple of years. Gordon doesn't like my sense of humor, I guess. That's about as fun as I get some days. But there are remedies if you understand what you're doing. See, wherever there's a problem, didn't anybody see Shrek 3D? Yeah. What did they say in Shrek 3D? Remember when Rumpelstiltskin got Shrek in that stupid contract, right? Who was the dude that came to Shrek's... Was it Donkey or... No. Puss in Boots. One guy came in and said, "You made a contract with Rumpelstiltskin? Are you crazy?" Pinocchio. Yeah, I love the way that DreamWorks makes fun of all of the Disney characters. It's just absolutely perfect. Pinocchio goes, "What are you, crazy? You're never going to get out of this contract." And Shrek's lamenting because he knows he's screwed because of his ignorance. And Pinocchio said, "Well, all you got to do is find the escape clause." And Shrek's going, "Escape clause?" And Pinocchio's going, "Every contract's got to have an escape clause." And so Shrek's going, "Okay, I'll look for it." And Pinocchio goes, No, you're never going to find the escape clause. The escape clause is concealed. It's coded. You will never find it. And Shrek's going, "Oh, you got to help me." So Pinocchio takes the document, and he takes a page and he folds it about 5 times so it looks like he's making a paper airplane. And out of all of the letters on the page, he folds it the last time, and all of a sudden there's a sentence there. And the sentence says something like, "If you can get," what's his wife's name? Fiona, "to kiss you before midnight, the contract's void." But they had to fold this thing 1,000,000 times to get that to pop out. So now Shrek's going, "Okay, we got to get Fiona to kiss me before midnight. And that will void the contract." Well, we're in some deep crap here. You better start folding the contract and find out what the remedy is. So what you need to do is look, if the birth certificate got you into the problem, collapse the birth certificate and it'll get you out. How you get in is how you get out. If you go to the movies and you find out what the remedy is, particularly when you go to the one here that came out last weekend, it tells you when you're in a dream, if you die in the dream, you go back to reality. Your life under the public trust 4, 5, and 6 was created by that birth certificate contract. If you can kill the contract, you drop out of the dream, the public trust, and you go back to life in the private trust. So all you got to do is kill the contract, kill the birth certificate. Doesn't Scripture say, unless you're dying reborn again of water, you will not live? Water is under admiralty. It's not the fulfillment of the law. It's a replacement to set off the obligations of the law and get your remedy. Question?
If everything is liened up in the private, well, is everything liened already in the private trust?
Good question. The liens are right here in box 3, which is the public, that's all the public holdings. Everything is filed. Your home is registered there. Your cars are registered there. Everything that's registered in the public constitutes something in the public which they can claim.
The birth certificate is that?
Well, the birth certificate is not collateral in the public that was created, like automobiles, homes, television sets, credit cards. There is something off this chart which is part of the DTC. And it is an asset account under the public number of the Social Security number for the straw man in box 6. And in that asset account in the DTC is a private account asset representing monetary numbers, X millions, hundreds of millions, billions of dollars, which is your private account in that DTC, which they cannot touch without your permission. And that is not the same account that you see in box 3. It's actually much greater than what's in box 3. You have a huge estate, which they have caused to grow hugely over your lifetime by rolling in dividends, interest, gains, plus everything a mirror image of what you do in this world. And your estate is huge there, but you have no knowledge it exists. You have no knowledge of how to go get it. and it's there for you, but they are the trustees over that account because you're incompetent and you can't get your gift. Remember, at lunch we were talking about this to some people. In Scripture, the Lord said that He was the owner of this great vineyard. And He went away on some foreign trip for a period of time, and He called in 3 of His servants and gave them a gift, no strings attached, before He left. To the first He gave 10 talents, to the second 5, to the last 1, 3, whatever it was. And when He came back many, many, many years later, he was going, well, gee, I wonder how they did. So he called in the first servant and said, how'd you do? And he said, great, I doubled it. Good and faithful servant. Second servant called in, I doubled it. Great and faithful servant. Third servant came in and said, you know, far as I know, you're a robber, a crook, and a thief. And because you're a robber, crook, and a thief, and you're a hard ass, I didn't do anything. I buried it because I knew you were coming back looking for it. Now the master goes, so I ain't going to argue with him. Let's assume that his confession is true. I am a hard ass. I'm a thief, a crook, and a son's a bitch. What'd you do with my property? Well, I hid it in the ground. Well, good, you stupid idiot. At least you should have put it with the bankers at interest if you thought I was a hard ass, so that when I came back, you could have given me my property back with usury. Now, most 501c3s say, well, that was when the Lord made it okay to do usury. No, that's not what it's all about. Usury was a capital crime. You were put to death for doing usury. So the master's going, you call me a crook, a thief, and a hard ass, and a bastard. Why didn't you say I told you to do usury so you could have killed me because it's a capital crime? Take everything away from him and give it to the people that have the other gift. Now remember, when we came into the world and Mom signed everything, our gift, into the birth certificate account, where'd that birth certificate account get invested? International bankers. Oh, so at least we should put our estate with the international bankers instead of burying it in the ground, so when the Lord comes back, He gets usury? Do you understand that none of us are doing anything right? So what we're doing now is we're looking to go reclaim that mistake that we made. We want to get our estate back, don't we? But if we don't go to get our estate back, we're abandoning it. Do you blame the shadow government for being a good trustee, investing our estate for us when we're so ignorant we don't even know it's there and we've abandoned it? Where has the shadow government done anything to harm us? If you had any idea of how many units were in your trust, you'd probably have a heart attack. But I guarantee if you hadn't had your mom invest in the birth certificate when you were born, you'd probably have no more money today than you had today. So why are you angry at this shadow government for giving you a vast fortune in your estate only because you're so ignorant you don't know it's there? And you're going to get angry at them because they didn't tell you? What the hell kind of a master are you to let the servants conceal your estate? So the remedy is go get that damn thing. How do you do that? Well, anytime somebody gives you a certificate, it is a document of title which you can redeem by turning back in. So if you want to redeem the transfer of the car to the government and they gave you a certificate of title, you sign the title on the back. The front is the public side, the back is the private side. You endorse a check on the back side, that's private. If you're getting paid by the company you work for, Ford Motor, they give you a paycheck. Who made that paycheck good? We did. When did we make it good? When we endorsed the back. They didn't pay us. We authorized the DTC to pay us out of our own account. But you didn't understand it was coming out of your account. You thought Ford paid you. But by signing the back, you're signing as box 2, the creditor. And you authorized them to take it out of your Social Security number account on the private side of the DTC and put it in the public account to the order of the straw man who now he goes out and spends. 2 minutes break. So what we have to do is understand that that trust, by way of the birth certificate, is something we can endorse on the back and turn in to the proper party under the trust. Haven't you just abandoned the assets? So now the one world government's got your fortune, which was the gift of God, which you've abandoned. Just like Esau. I don't care what God gives me. Abandoned. Just like Esau. I don't care what God gives me. I'll just go on my own. Didn't God always get ticked off for his people for not taking the gifts that God gives them? The estate. And yet we don't even go after the estate God gave us. We let it in the hands of the sons of Cain. One more thing. Your estate is centered in 10 Social Security, red number on the back. That red number on the back is a bond at a Federal Reserve Bank in a private account, which signifies 1/10 of your estate that they hold for you. There are 10 cards with 10 different numbers. If you acquire all 10 cards, you can cash them in and get back your estate. Then you can cash in the birth certificate, collapsing the birth certificate. Your straw man name will, and you will have the equivalent of sovereignty without being liable to all of the obstacles, the licenses, all of the would allow you to do in commerce. Do you understand you would not stand in the search line at the airports? Do you understand that you can get? That's why these classes, that's why what Brandon is teaching is so important. You're going to spend time now in the next 2 years learning how you're going to extract yourself from these problems, or it might be too late. You're going to be ushered in as a box 6 under a new world order with no government protections, pure debtor. You will go where they tell 12. What's in those issues? They were told, we're not going to tell you, pass it and then we'll tell you. Have they started telling you? Do you understand that what's in there is surrender of all firearms? Because if you're a debtor with absolutely no standing, you can't have a firearm on your master's plantation. Do you understand that taking the mandatory chip in your body so you can be identified with an RFID chip is mandatory in 2013? And you cannot resist unless you want to go straight to prison, do not pass go? Because haven't we told you your body is the currency? What do they do with the currency in the military? Serialize it. They got to keep track of it. That's your body. Your body will be kept track of by that chip. You have no ability to resist. You're not a creditor. You have no standing. You can start seeing with this model that there's a lot of interesting things that are coming up and who you are and what they're planning to do. You can see the handwriting on the wall. You can see Hollywood warning you at every turn that this is exactly what's going to come to fruition. You better start getting your act together. The only thing I am really concerned about is if everyone in this room can actually collapse the straw man, become the creditor, what are you going to do with your spouse and your children and your parents that won't even listen to you and plan for this? Are you going to be able to save them? I don't know. That is a good question. But evidently, if you're being called to learn this and understand it, you're being called for a purpose, you better heed that warning, because you have some duty, a higher calling, that you need to understand what you're being called, not be in a position to help themselves. You know, the whole parable in the New Testament about the virgins with the oil in their lamps and they were not ready has something to do with things that we're seeing that may be about to come to pass, and we better be prepared to be able to take care of these things. We've seen the dual trust. We have only begun to talk about what we could talk about in this diagram. But I wanted to show you why we have created that diagram. And like Brandon said, once you get this concept in your mind, and you can see who they are and where they're playing their game from, and what you need to do to go through to get your remedies, because your remedy is through the Secretary of Treasury, Secretary of State, Attorney General, U.S., and these private international corporations, which are set up for you to get your remedy. Your remedy is not in any of the corporations or any of the government facilities in 4, 5, and 6. They only deal with slaves. And unless you want a slave remedy, those are not the places you're going to get your remedy. You're going to think bigger. You're going to stop fighting this whole concept that the shadow government is evil. They represent your trust. Go get it back. They cannot stand in the way if you do it right and you treat these people with respect. That's your bigger job. If you came here to learn how to solve a traffic problem with Box 6 or a foreclosure with Box 6, that's a good start in learning procedure. But you're way down in the scheme of where we need to go in about a year.
These Creditors in Commerce workshop sessions, hereinafter sessions, are the private exchange of ideas and concepts between the providers and the recipients. The content is not meant as legal advice. The use or attempted use of any idea or procedure discussed in these sessions, as applied to the recipient's own personal transactions, cases, or controversies, or applied to other cases, may or may not result in a favorable outcome or the same outcome as discussed in these sessions. Each transition or transaction, case, or controversy may be different as a result of unique actions or unique statements made by the parties therein, and each different act or statement in any transaction affects or may affect whether any procedure or idea discussed in these sessions is relevant to the recipient's transactions, or that the outcome thereof will be depicted as in these sessions. The discussion of ideas or procedures in these sessions is not exhaustive of the subjects being discussed. Many ideas and concepts that can affect the outcome of any legal or commercial procedure are not discussed in these sessions, and the fact that the recipients may not be aware of these issues may have an adverse effect on the outcome of the recipient's procedures. It is the responsibility of the recipients to understand another recipient requesting them, condition upon the fact that this notice is provided therewith. If you have any questions, you may contact Creditors in Commerce by email at harmony@creditorsincommerce.com. Okay, so preview of the public trust, private trust, the roles therein. So with that, and we discussed briefly, just did a search on Google and type in Bouvier's, which is Bouvier's, law, or if you have Bouvier's dictionary, legal dictionary, it has a great section on maxims, and it has them in Latin and translated into English, and it goes through, I would say I want to say it has over 100 in there, maybe several hundred.
There are literally thousands of maxims.
Yeah.
Read some of them, just like Brandon, you heard he picked up some that speak to him. There's some I pick up that make sense to me with the way I think and that I use to balance what I'm thinking about. So he's giving you that Bouvier's is a
foundation of law. So when making your contract, when you keep those maxims in mind, and you may even list them in your contracts as the foundational law of the contract. My brother had an interview a couple weeks ago, and the first thing he did, besides establish his authority by telling him, okay, sit there, it was as if he was conducting the interview, and he established the maxims of law that were going to be held in that particular interview, so that he could establish, here's the law that we are under today. So yeah.
We ought to have Garrett, give us a 5-10 minute thing on it. Well, if you could keep it down.
If you want,
because it's a story well worth hearing. If you corner Garrett,
it's one of the best creditor stories ever. And but I know do you want to cut it out of the video?
I'll tell you what, we'll do it after dinner, because I want to at least look at my outline. Otherwise, I'll forget it.
Let's hear from him after dinner, because he's got a great story. And when you go on My Monday Night Last and listen to Brandy with his story, some of you have heard it from last Monday night, and you couple it with some of Brandon's and Jack's stories and mine, you just understand that truly consent makes the law.
Yeah, actually, Gordon, on his, it's a Monday night call you do, right?
Yes.
On Gordon's Monday night call, a lot of times what they have on there is a worked for me.
This is real life experiences by our students that have used them both successfully and unsuccessfully, and what their thoughts are and how it worked for them. And it's just wonderful to see that these people can do it, just like young Alina here earlier. This gal she's learning the principles to do. You just don't answer questions except with questions. We teach youngsters
that we don't not answer questions to impede the process, but to establish that we don't take a position on things. And what I mean by that is, so often we want to be right and assert something. And in order to choose a certain line of questioning, if you had tendered an instrument for set off of a debt, and you were asked, well,
didn't show up, you need to give them a little story about that so they have a basis to understand this.
Right,
better.
and actually I had a district attorney, or what do you call it, a folder. First thing, he points to this instrument. He goes, well, is this your signature on that instrument?
This is just a copy of an instrument, too, isn't it?
It was just a copy of an instrument. However, the presumption there was that there was something wrong with the instrument, right?
So see, the issue isn't this is his signature. The issue is there's something wrong with it. So if he answers the question with a yes or a no, he's going to feed into what the presumption is. And he's not therefore going to have rebutted the assumption or presumption, and there's going to be a problem.
Yeah.
So what did you say?
So I asked the question. I said, is there a defect in that instrument?
Now he's going to, that's offer, counter offer, and he's going to have to come back and accuse him or make an accusation. He's not going to do that.
Right.
The government does it right.
And then he actually proceeded to go, well, I don't know. So then I asked another question. I go, well, are you telling me you're not qualified to make any determinations about negotiable instruments? He said, well, if there is no defect and you're not qualified to make any determinations about